rise. Justices of the Appellate Division, Supreme Court, First Department. Hear ye, hear ye, all persons having business with the Appellate Division. Draw near, give your attendance, and you shall be heard. Please be seated.
Good afternoon and welcome to the Appellate Division First Department. Most of you know the drill. The panel is familiar with your briefs, the record, so please only ask for the time you need, not the time that you want, so that I don't have to do it for you. Please understand that the time that is allotted by the court is a time clock for you, not for us. So if we have more questions, we'll keep asking questions. So do not fret that you're not getting enough time. If indeed there are real issues, we will keep asking questions. We presently have 16 cases asking for argument time and 6 hours of argument time requested. Clearly, nobody wants to be here until 10 p.m., okay? That being said, People versus Luis Feliciano.
I'll request 3 and 1.
3 and 1 and 3, and thank you for listening. Hoffman versus Hoffman. Do you have a cross appeal? Then you don't get rebuttal time. So that is 5, 2, and 5. F. Children is submitted. Morale versus Cova Media Group. Thank you. You were listening. 5 and 1 and 2. Lee versus 124, 126 Mott. Okay. It seems you've scared off the respondent. Would you like to submit? Thank you so much. People versus Reyes Guerrero. Okay. 3 and 1 and 3. Centennial Elevator versus GRM Construction. 5 and 1 and 3. Infant versus New York City Health and Hospital Corporation. Okay. 3 and 1 and 3. People versus Alantha Ingram. Submitted. Besios versus Regent Associates. Okay. You have a cross appeal? Okay. All right. So I will do 5 and 2 and 5 and 1. Matter of Adonis, submitted. People versus De La Cruz, submitted. People versus Oliveri. 4 and 1 and 4. Intrepid Investments versus Selling Source. Okay.
Respondent Selling Source request 3.
And Respondent White Oak requests 2 minutes, Your Honor.
5, 2, 3, and 2. Florence Capital versus Axis Insurance.
Well, good afternoon, Your Honor.
Hi.
Request 7 and 2.
Okay. Okay.
Respondent Access Insurance request
4. Okay.
Respondent World Insurance requests 2, Your Honor.
You're here for whom?
For World Insurance, Your Honor.
Okay. So 5 and 1 for plaintiff. Flanagan, 4 and 1. Over here on the right, 4. And you have your 2. Thank you. Okay. Antignac versus City of New York is submitted. People versus Juan Rivera.
Good afternoon, Your Honor. Appellate request 4 and 1.
4 and 1 and 3. Mena versus 5 Beekman property. 4 and 2? Okay. Okay, you have a cross appeal? All right. Anyone else? Hi. Okay, 4, 2, and 4. 4, 2, 4, 2, and 4. Gerardo versus Breton is submitted, and Servitor versus City of New York is 4 and 3. Those have been approved prior to the call of the calendar. First case on the calendar, People versus Luis Feliciano.
Good afternoon. May it please the court. My name is Elizabeth Vasily, and I represent appellant Mr. Luis Feliciano. The court wrongly ruled that the prosecution could admit hearsay statements of the complainant's neighbor, DeSena. The court admitted her 911 call and wrongly concluded that it was a present sense impression. But the neighbor did not witness the event in question. She never saw what happened in the elevator, and she only heard about it from the complainant.
Counsel,
and then,
even if we were to agree with you that that may have been an error on the part of the trial court, given the video evidence in this case of the event and the statements, the excited utterances of the young woman victim, wouldn't that be enough anyway? Wouldn't it really just be harmless error?
Your Honor, the video does not contain audio. So when the question...
Does not contain what?
Any audio.
Does that matter? When the video clearly shows this grown man attempting to grope a young girl on an elevator. Not once, but twice, and her pushing him away and fighting him off. The video is clear. Okay?
Your Honor, the video also could show an equivocal explanation of him trying to take her cell phone. He's with a single hand.
Her cell phone was here, not down here. And clearly his right hand was going toward her crotch.
The video...
Please don't tell us we didn't see what we saw on that video. Please don't make that argument.
Regardless, when the question boils down to his intent, and you have these statements coming in that he's intending to rape her or intending to grope her, then that would not be harmless when the defense theory in this case was that he was trying to take her cell phone.
Counsel, isn't it true that you had the neighbor testify at trial, right? So you were able to cross-examine.
The hearsay statement still came in, though, and under the present sense impression rule, it doesn't matter because she testified to what the complainant was saying at that time.
I understand that, but as my colleague said, even if we accept that as true, what prejudice is there? You had the declarant of that statement on the witness stand, and you had the full opportunity to cross-examine her.
The prejudice, Your Honor, is that they were able to get in statements that occurred right after the offense to bolster their theory of the defense, or their theory of prosecution. And additionally, the complainant's statements in the 911 call were also excited utterances. There had been a gap of time. She had told her story once. I see that I'm out of time.
You can continue your statement, please.
She told her story once to the neighbor. She sat down. There was a change of scenery. And then she was responding to structured questions from the 911 operator. So it's our position as well.
Wasn't it just a few minutes, though? We're talking a few minutes, not a huge amount of time.
That's correct, Your Honor. It was at least 5 minutes. So that is...
And didn't the officer say that during the questioning, his questioning of her, the victim was still responding in an emotional way under the impact of what had just happened to her?
Yes, Your Honor,
It would certainly qualify as an excited utterance.
I was referring to her statements to the 911 operator. The officer, those are separate statements later.
Except that the statements to the 911 caller happened before the statements to the police officer. So if the statements to the police officer are an excited utterance, certainly the statements a few minutes earlier to the 911 caller, to the 911 operator, shortly after the event happened and after she secured safety in the neighbor's apartment, that would certainly qualify as an excited utterance, no?
Our position is that neither are excited utterance given the time gap. I see that I'm out of time, and I'll reserve the rest for later.
Thank you.
May it please the court, Karen Schlossberg on behalf of the people of the state of New York. It's our position, obviously, that these statements were appropriately admitted, all of them.
Counsel,
Go ahead.
does that include the statement from the neighbor? The neighbor
Yes.
didn't witness anything, so how is it a present sense impression?
Because, Your Honor, it's not like the cases my adversary cites where a 911 call comes in and we can't tell from the 911 call whether the person who is making the statement personally witnessed it. We don't know what the basis of knowledge is. Here, the 911 call, Desena, her name is Carmen Desena, she was very clear with the 911
But
operator.
that doesn't matter. Under a present sense impression, isn't the entire theory of present sense impression that the person reporting had an opportunity to view
Yes.
the encounter in question, and there's no issue that here the neighbor did not see anything. She gets a child at her doorstep
Yes.
who's frantic.
Well, our argument is that the statement that the victim made to her, someone's trying to rape me, was obviously admissible. It's prompt outcry, excited utterance. And when Carmen Desena heard that, her present sense impression is that she heard that statement, much like you'd hear a bullet or you'd hear a gunshot. She heard it, and she's describing to the operator what she heard.
But she goes beyond describe. I mean, it's one thing if the neighbor said, "I have an hysterical child here. She's reporting an assault." I mean, that's one thing. But she goes beyond that and says she was either raped or groped. That now goes to the truth of the matter asserted by the child.
I mean,
no?
I understand what Your Honor is saying.
So
Our
I'm
position
sorry,
is,
counsel, isn't a better argument that it's harmless error?
I was just going to move on to that. What I was going to say was, it's our position is that is essentially what she was saying to the 911 operator, is that this girl came in and told me this. We are saying that. That's what it's tantamount to. But at the end of the day, if it was an abuse of discretion to allow this statement in, as was articulated in the questioning of my adversary, it doesn't matter at all. Carmen Desena was there to be cross-examined. The victim was there to be cross-examined. The evidence in this case was so overwhelming, including not just poor Cherry Song's testimony, but also the videotape. This one statement that was admitted to the 911 operator could not possibly have affected the jurors, who, by the way, were very clear with their verdict, that they were carefully examining the evidence. They did not convict of the highest charge. There was no prejudice here.
Thank you.
Unless there are any other questions, I'll just rely on the arguments in my brief.
Thank you so much. You may proceed.
And just briefly, Your Honors, the law of present sense impression is, quote, spontaneous descriptions of events made substantially contemporaneously with observations. And as my adversary argued, a statement is not an observation. And here, you don't see a statement, you don't observe a statement, you hear a statement. So that's not what the law requires, and it's also not an event.
But when you look at the overwhelming amount of evidence, as counsel stated, isn't this, at the end of the day, harmless error? I mean, you have the complainant testifying, the officer that says what her demeanor was when he saw her 25 minutes after the event, the witness, Desena, who made the 911 call, who could also describe her appearance. Then you have the videotape. What more do you want? When you couple all of that evidence together, it's overwhelming. And to say that the admission of this one statement by that witness when she called 911 should be sufficient to overturn this, at the end of the day, this is harmless error.
It's our position that it's not harmless, Your Honor, when it comes down to just the single witness, the complainant, her saying what happened.
What about the video? The video.
The video, as I said earlier, does not have audio in it. And
You don't need audio. You can see what he's trying to do to this young lady.
It's also equivocally stealing a cell phone, and that was the defense theory. And the statements of a third party, another person bolstering it, is not harmless.
So the complainant made all this up. She made up everything, despite the fact of what's depicted in the video. Because she wants to hurt this man, whom she'd never met before. She made it all up. And she ran to a door and knocked on it frantically and had the person inside that apartment call 911 and get this entire operation going simply to get this particular individual. Is that what you're trying to say?
No, Your Honor. This was a very sad case for the complainant. This was a very scary situation. A man is in an elevator with her, and he's reaching at her body. There's a language barrier. She hears things that she has headphones in. She's assuming the worst, and she's so scared and frightened. But that doesn't necessarily mean that that was Mr. Feliciano's.
Also, the defendant never got a hold of the cell phone, did he?
He did not, Your Honor.
Did the video also show that she's trying to get away from him, trying to leave the elevator, and he keeps holding her back?
It does, Your Honor.
It does. Okay.
Thank you so
I'm
much.
out of time.
Thank you. Hoffman versus Hoffman. You may proceed.
Thank you. May it please the court, Mossberg, Sharma, Stambleck, Rose for appellant Philip Hoffman. I'll keep it pretty simple because it's really based on the statute. CPLR 5003 provides for post-judgment interest on a money judgment. In this case, there is no money judgment for the monies in question on this appeal. A money judgment is defined as a sum of money. Neither the judgment of divorce nor the decision from which...
Counsel, can I ask you a question?
Sure.
The distributions that she seeks, I know there are issues with respect to them, but isn't that her money? And she doesn't have the use of her money, and shouldn't, based on that, she get some interest for not having access to that asset?
The issue, Your Honor, is that we don't know what the money she is owed is. It could be zero. Because of the way the judgment of divorce...
Well, then 0% interest, so it's 0% interest, so that there's no prejudice there. And if it's
Except for the-
$10, then there's a little bit of interest.
Except for the fact that post-judgment interest is only awarded on a sum certain on a money judgment. There is no money judgment. So while there is the judgment of divorce, paragraph 40 provides for an accounting to be done with respect to these monies as offset against marital expenses, that was done and has been going on since the judgment.
So in other words, it's your position that the husband can hold the money interest-free until all these issues have been resolved, which could be years.
Yes, Your Honor, because with respect to that...
Doesn't that seem a little bit unfair?
It doesn't, Your Honor, because they have both been trying to figure out this accounting. The trial court even said there are issues of fact. They have gone back and forth over accountings because of this money, with taxes, with marital expenses, with what the distributions have been. They've been unable to figure it out.
The husband could turn it over and then recoup it if it turns out that she wasn't entitled, right?
Except, Your Honor, it doesn't provide for the husband to recoup it, and he would not be able to recoup it with interest, presumably, based on the decision.
Well, if it's his money, then presumably he could make the same argument, you know, what's good for the goose is good for the gander.
He could, but he'd have to come back to court and make that argument. The judgment of divorce does not provide for a money judgment. It does not provide for interest. The decision that we appeal from does not provide for a money judgment. It provides for the referee to help determine what the amount owed is. It specifically states there are issues of fact with respect to the accounting and the monies owed. So the award of post-judgment interest was improper under the statute and would simply just result in a possible windfall to the respondent when none is warranted. With respect to the issue of modification of child support, the trial court erred because appellant made a prima facie showing that there was a substantial change in circumstances and 3 years had passed since the last order. He provided financial information of the substantial change. He provided a net worth statement. He provided a tax return. Respondent provided nothing. She did not show that her financial circumstances either remained the same.
I thought for a modification, it's only on the, no?
It's not, Your Honor. The
Okay.
statute,
He has to show a change of circumstances first, though, as a prima facie showing.
and he did, Your Honor. He showed that his net worth would be substantially less based on this court's decision in July of 2019.
So he's using an award of this court in order to substantiate his.
Yes, Your Honor, because some of his, he had 75-25. This court reduced it to 50-50. A lot of the money that's reported on his 2019.
But if
tax
that
return-
was a corrected error, then why should he benefit from that?
Because
As a basis for modification. If the court below made an error in distributing that particular asset 75-25, and this court decided that it was a marital asset that should have been split 50-50, why should he then incur a benefit from that?
because the trial court, in determining child support, relied on respondents' investment income, and it specifically used her interest income on that 25% to determine her share of the combined parental income, to do the calculation to figure out what the correct child support amount was and what the add-on distribution should be. So by nature of this court modifying the award from 75-25 to 50-50, that child support piece is directly affected.
Does it make any difference that one of the children has since become emancipated since this decision was done, so there's a change anyway?
It doesn't, Your Honor. I mean, the child support, the application to modify dates to December 2020 when it was first made before that child emancipated. So it would be for a short period of time with respect to that child, yes, but it would go forward with respect to the add-ons and the basic child support with respect to the younger child.
Okay, you'll have time on rebuttal.
Thank you.
May it please the court. My name's Lori McPherson. I represent the defendant, respondent, wife.
Counsel, do you agree with your adversary's position that in terms of the support, that the court based it on projected invested income as opposed to imputed income?
You're right, Your Honor. It was actually the court relied principally on imputed income because they averaged his prior year's earnings and imputed no less than, I think, $4.6 million a year. And that's what he failed to show the court on his claim for an upward mod, because he could not substantiate financially, as Justice Hoffman found, that he was no longer able to make as much as $4.6
And isn't there indication in this case that the husband does have significant earning potential?
Absolutely.
Which he has maybe taken himself out of for whatever reason.
She never worked, I think, beyond being a Sunday school teacher after, I think, they were married for a long term. So she didn't work since the kids were born. But counsel's wrong on that. This was not the child support issue was not determined based upon relative investment income, but as Your Honor quite rightly noted, his earning potential, which was huge and remains to be huge. It has been almost 6 years since the trial in this matter. My client still doesn't have her fair share of the marital estate, despite the clear orders of the trial court and the modification issued by this court granting her a full 50% of the estate.
Why is the accounting taking such a long time to do?
Because of the plaintiff husband.
Have documents not been produced? I mean, are you?
We went through it all. If I may, Your Honor, the judgment, it is absolutely outrageous for the husband to try to claim that he has paid timely and done everything as he was required to do. Under the judgment that was issued by the referee's determination, he had 45 days to provide an accounting and pay over the distributions owed to my client. He waited 4 months before he gave an accounting, which was flawed, to say the least. But even under his own admission, he owed her no less than $600,000. Did he pay it? No. In fact, he never paid a penny, not a penny, until 2.5 years later, and only after Justice Hoffman ruled in our favor on a motion to enforce and granted post-judgment interest. In November 2020, he finally paid her $1.8 million, which is a portion of what she was owed. This was over 2.5 years
So going
after
back
he
to
was
the,
required to do it.
the issue of the interest rate, your adversary says that there's no judgment here, it would be inappropriate. One concern one might have is that if we do agree that, that your client's entitled to 9% interest, that, that it may there'd be less incentive for her to settle the case. Should we be concerned about that?
No, you should not.
And why is that?
Post-judgment interest is to compensate her for the loss of the use of the money. Counsel is absolutely wrong in trying to refashion and rewrite the statutes. The statutes don't require only a money judgment. But CPLR 5003 specifically provides for post-judgment interest for orders directing the payment of money. That is exactly what we had here from the referee's determination back in 2018.
But we don't know how much money.
That is true. That required, but that doesn't mean that we would delay any consideration of interest until it was a sum certain, fully determined after all hearings and all appeals. Effectively, that turns the law on its head because it denies my client the very protections that the statute is designed to provide. You get, and this court and many courts routinely order post-judgment interest after appeals and retroactive to the date of the judgment, because that's the only effort that will be sufficient to compensate my client for the loss of the use of the money. There's no question that my client has every incentive to try to get her money so she can use it. The husband has fought her at every turn. Justice Hoffman was not just appropriate, but he was eminently reasonable in ordering the 9% interest. Nothing less than that would compensate her for the loss of the use of money, particularly in the last 3 years, when the S&P alone has delivered somewhere in the nature of 28% one year, 16% another year, 26% in the last year, in 2020 and 2021. She'll never get that back. Notably absent is any claim by the defendant husband or the plaintiff husband as to what he's earned in this time. I dare say, if he didn't think he owed my client any money, he wouldn't be so interested in fighting for post-judgment interest. And with that, I would, unless you have any other questions, I'll rest on my papers.
Thank you so much.
Thank you.
You have 2 minutes.
Thank you. The Second Department in Parkoff v. Parkoff specifically denied post-judgment interest on a judgment of divorce where there was no distributive award.
Why should we follow that case?
It's instructive. It's not binding on your honors, I'm aware. But the cases cited by respondent in her brief and by Justice Hoffman in his decision that award post-judgment interest all relate to distributive awards or money judgments. Not one of those cases is a case where there was a amount of money that was unknown that's supposed to be figured out and paid, and interest continues to accrue on that amount of money. Those cases don't exist, and they're not in respondent's papers. Your Honor made a point about 9%.
Is counsel correct that even after there was a figure, your client has not, it took enforcement proceedings to pay, and why, under those circumstances, is she not entitled to interest in that situation?
Your Honor looks at the record and the motions leading up to Justice Hoffman's decision. Respondent's number for what she claimed she owed changes in every single set of papers. It's been a moving target.
Well, it grows as time goes on, so that's not
based
unusual.
on the interest. Not based on the interest, Your Honor. Based on what she believes, marital expenses she disputes, doesn't dispute.
Counsel, if I may, the question is not what the wife is saying she's owed. It's what the husband said he owes. Why didn't he pay that prior to enforcement?
In November 2020, before November 2020, there was no amount that was agreed upon to be owed, and the husband, the appellant, excuse me, believed he owed a lot less. In November 2020, we went through all the numbers again, and he paid between November and December approximately $1.9 million. Since that time, respondent has refused to engage further in trying to figure out the disputed amount, which is sitting in an escrow account. So to Your Honor's point, she is taking the effect of 9% interest and just letting it roll out. We have a trial coming up in January with the referee to determine the issues of fact, what is the amount of money owed, and she had no incentive until that time to do anything other than wait and sit and collect interest at a rate that is inappropriate when there shouldn't be any interest.
But except, I guess, well, I'm not persuaded by that argument because she doesn't have use of her money, and she cannot invest it and do all the things that she may want to do with it.
Well, neither one of them has use of the money that's in escrow, Your Honor, and there's a case Vogel that specifically states that interest.
But that's not the only money he has. So he is able to invest the rest of his money while she sits and waits with nothing. But we have your argument.
Thank you, Your Honor.
Thank you. Okay. Mural Inc. versus Cova Media Group.
Good afternoon. Peter Rippin from Davidoff, Hutcher, and Citron for the appellants. May it please the court, I'd like to introduce my co-counsel, David Schechter, of the Miller Barondess Law Firm in Los Angeles, California. Mr. Schechter was admitted by this court to appear pro hoc vice in connection with this appeal. I respectfully request that Mr. Schechter be permitted to argue the appeal.
Your application is granted. Welcome to our court. Even though we have over 100,000 New York lawyers who could have done this case, we welcome you. You may proceed, sir.
Thank you, Your Honor, and I don't disagree that there are plenty qualified New York attorneys who could have handled this case, as the record reflects. So, my co-counsel introduced me. I represent appellants and defendants, Artist Group International, a talent agency firm, and Kovac Media Group, also known as 10th Street, an entertainment management firm. I note that I've been given limited time, so I'm going to jump right to it. The most significant issue on appeal is the timeliness of the summary judgment motion and whether there was good cause to file it when it was filed.
Counsel, in our jurisdiction, a Supreme Court justice is entitled to shorten that time, so long as their rules are published. And there's no question that this judge's rules were published. On top of that, you have at least 2 orders that specifically cited the 60-day time frame. So you are, in the kindest way that I can say, you are swimming upstream, my friend.
I understand that. There's no dispute that there were mistakes were made across the board. They shouldn't have been made. It is our fault. We take responsibility for it. We've made sure that it's not going to happen again. In preparing for oral argument, Your Honors, we noticed actually that the motions were timely filed, and I'd like to walk you through this.
We are talking about the 60-day time.
No, they were filed timely per New York law.
No, they were not, because as I just said, a judge has a right to shorten that time period, and this judge did. I cannot allow you to ignore that. So I will entertain any argument you have about why the judge's 60-day rule should not be honored. It will be a first that we so hold.
They were not filed within the 60-day period set by Justice Freed. There's no question about that. Executive order, however, by Governor Cuomo, Executive Order number 202.8, which came down on March 20, 2020, told the running of deadlines for not just statute of limitations, but also for motions. That executive order number 202.8, was extended by the governor's office by executive order number 202.67 through November 3, 2020. In Brash versus Richards, this was a decision by the Second Department in 2021. The Second Appellate Department held that the governor's executive order operated as a toll and not a mere suspension, and that the effect of that toll is to add 228 days to deadlines, which include
How
motion.
can we add 228 days to a timeline that on the statute is 120? That is ridiculous on its face. You would be more than doubling what the statute says you have. So now you want to turn what is normally 120 days into 220 days?
I don't want to do it. That's what New York law
That is the
says.
argument you are making. It is turning our rules on its face.
The governor's executive order is part of New York law. The decision of Brass versus Richards is New York law. And this judicial department
It's not binding
last
on
month,
this department. So explain to me why we should follow a rule that would double the ordinary time.
Just last month, November 1st, 2022, Murphy versus Harris, this judicial department adopted Brash's reasoning and held that executive order number 202.8 as extended operated as a toll. So it's not, I'm not just arguing it, this is what the
Was
executive...
that a summary judgment motion? Where the court had limited the time to 60 days?
These are, the cases deal with statute of limitations, but if I could just read the language of the original order. Any specific time limit for the commencement, filing, or service of any legal action, notice, motion, or other process or proceeding as prescribed by the procedural laws of the state, including but not limited to the...
Counsel, let me stop you for a second. Isn't it right that you're making this argument for the first time on appeal?
I am. That is conceded. It's not in my papers. My co-counsel and I, we discovered it in preparing for oral argument. Again, I apologize for that. It should have been in my papers. But we did argue below and in our moving paper, in our opening brief, that COVID was one of the reasons. Our argument was enough to give my adversary notice so that they could put it in a footnote in their brief where they reference this exact executive order and Brash versus Richards. So it's in the record, Your Honor. And the new development is that just last month, this judicial department held that the executive order operates as a toll, which means to add 228 days.
Right, on a statute of limitations case. Just to be clear. Okay.
Correct.
All right.
I see that I'm out of time.
You'll have time on rebuttal.
Good afternoon, Your Honors. Greg
How
Friedman,
much time
correspondent.
after the last extension expired was this motion filed?
The extension, you're talking about the COVID toll, correct?
Yes.
Expired as of November 4th. Their motion was filed, I believe, February 25th.
So that it
November
would have been
2021.
in excess of the 60 days of the court's rules, even if we were to accept this argument.
Well in excess, and I just want to add, even though we all know that this argument wasn't even raised by them on appeal, it's being raised for the first time here before Your Honors, that no court has held that the toll gave them an additional 228 days. We all know that. The time was still 60 days, so even when you factor in the toll, they're still wildly late. I think you hit the nail on the head with regards to the timeliness. I don't need to drive it in any further. They didn't satisfy Brill. That's really the end of this story. If you would indulge me, the only other point I wanted to make was about this disclosed principle argument with AGI. It would take no more than a minute.
Yeah.
Even if the court could have addressed that claim or that defense on the merits, there was no disclosed principle here. Their argument below, and their only argument below, was that Motley Crue was a disclosed principle. It was their burden to show that Motley Crue is some kind of legal entity. That's the whole point of a disclosed principle. If a plaintiff needs to go after somebody for a breach, they need to know exactly who to sue. You can't sue a fictional entity, and that's why plaintiffs were entirely correct in suing AGI. Now, they first put it in their reply brief on appeal that actually, no, it wasn't Motley Crue. It was this other company, Red, White, and Crue. They didn't argue it below. They didn't even argue in their main brief. If you look, I think it's page 26 of their main brief, they again said Motley Crue is a disclosed principle. So them suddenly changing course in reply and appeal, it shouldn't even be considered, but either way, they didn't meet their burden on that issue. Are there any questions? Otherwise, I'll rest on the brief.
Thank you so much.
Thank you.
Counsel, you have a minute on rebuttal.
Thank you. There are cases that have held that the toll is to add 228 days. There's a case from the Southern District of New York, Powell versus United States, 2022 WL 1645545, which held that the statute of limitations.
Counsel, I'm familiar with some of the tolling cases, even in the first department. But, those were issues that were raised below, litigated below, and then raised on appeal, and we made decisions. You concede that you'd have done nothing like that. Isn't that sort of trial by ambush? I mean, you come in here and make an argument that we hear for the first time.
It's not trial by ambush. My adversary addressed it in their opposition papers, and it is the law of the state of New York. We ask that the panel apply the law of the state of New York, and if you conclude that it's not in our papers, we ask the courts sua sponte find that the motions were timely filed. The merits speak for themselves, if I could just briefly.
I'll allow you 1 minute.
Thank you. The merits speak for themselves. We represent talent managers and talent agents who never should have been sued. Our firm was served with a lawsuit in 2016. Shortly thereafter, we informed plaintiffs who they should sue. We told them who to sue. Motley Crue, Red, White, and Crew, Inc. That's who the parties that they should be suing. They chose not to do that. They burdened our clients for years litigating this case, and the burden was one of the reasons why we didn't hire local counsel, which is a massive mistake that we recognize should have been. We should hire local counsel going forward. But our clients never should have been sued. The summary judgment motions are meritorious. We ask that this court reach the merits.
Thank you. People versus Reyes Guerrero.
Good afternoon.
May proceed.
My name is J.D. Colavecchio, and I'm pro bono counsel for Mr. Guerrero in his sentencing appeal. Mr. Guerrero was sentenced in March of 2019 to 6 months in jail and 5 years of probation. So since the time that he was sentenced, he's completed that 6-month term in jail and has served over 3 years of that probation sentence. So what we would ask is that this court reduce what remains of his probation sentence down to time served as of the time that you render your decision in this case.
So really what he has left is about 1.5 years.
Approximately a little more than that, right?
And has he received any credit for the new program of, what's it called?
Less is more.
Less is more?
No, to our understanding, it doesn't apply because he received a probation sentence rather than receiving parole.
Ah, okay. Well, I'm glad you shared that with us. Anything else you want to share with us?
Yeah, I would just respectfully request that you take into account his age. He's 63 years old, and he is diabetic and suffers.
Yes, but he was a few years shy of that, but he was already a man of mature age, I'm going to say that. Right? No, not even advanced at 60, I'm just going to say mature.
An ideal
right?
age.
Right? And yet he allowed a double parking aggravation to have him lose himself and stab someone in their chest?
To be clear,
It sounds like maybe he might benefit from continued observation so he stays in control. What do you say to that?
we do not contend that the circumstances of the offense are what would weigh in the interest of justice in mitigating his probation term.
But he has a history of, there's been orders of protection against him, for example. So they are, as my colleague is suggesting, he has anger management issues. And couldn't services actually be beneficial for him under the circumstances?
No doubt services could be beneficial, and he was actually ordered to attend anger management classes in the pre-sentence report. But all of that can continue to be done not while serving a probation sentence. And it is burdensome for someone of his age, with his only income at this point being retired, being Social Security, and struggling with multiple health conditions, that to the point were severe enough that the sentencing court acknowledged them in rendering a split sentence. It's those circumstances that we would submit are meriting a reduction of his sentence. Thank you.
Thank you. You may proceed.
Your Honors, and may it please the Court, Anna Nachik for the people. Defendant's agreed upon sentence was fair and appropriate and should not be disturbed on appeal. Defendant was originally indicted for attempted first-degree assault and second-degree assault, but this plea deal allowed him to avoid the mandatory 2-year incarceration term on the second-degree assault and receive an alternative sentence of just 6 months incarceration.
Has anything occurred during his time on probation that would cause the people pause or concern in us even entertaining a reduction? Is there anything that has happened since his sentencing and release that this court should consider?
Not to my knowledge that he has violated probation at all. However, we do submit that if a crime like this were to happen again, the severity of harm that could occur would be great. This was a very serious offense where a defendant did stab someone in the chest for blocking in his car. And for that reason, and given the leniency of his plea, the sentence was not excessive, and if there are no further questions.
What about his medical conditions? The adversary says we should consider his medical conditions. Isn't that a fair point?
Well, Your Honor, while defendant's medical conditions are a factor, that was evidently considered by the people in allowing him to plead, and the court below, in allowing him to plead to this plea deal that he avoided a lengthy incarceration term and had a split sentence of just 6 months incarceration followed by 5 years of probation. And if there are no further questions, we ask that you affirm. Thank you.
Thank you. Okay, counsel, you have a minute on rebuttal.
So counsel, your adversary essentially argues that this was a negotiated sentence. The defendant received a below minimum sentence, because generally the sentence for second-degree assault is 2 years. Why should we tinker with that at that time? Because it was a favorable disposition to your client.
That's correct, that he could have received that sentence, but the sentencing court evaluating circumstances that even at that time did include his age and his health conditions determined that a split sentence would be more appropriate. And it is worth noting, of course, while a split sentence is more favorable than a 2-year term in prison, he did receive what is the maximum that you can get under a split sentence.
Well, it's not he received, it was a negotiated plea, right?
Right.
Yeah, and on a felony plea, the probationary time had to be 5. Correct? Only a misdemeanor can get a lower probationary sentence, correct?
I am not sure of that.
Okay.
I'll trust your judgment.
All right.
Thank
Well,
you.
I want to thank you on behalf of this court and thank your law firm for lending you to us to serve on this case. We give you our appreciation and that to your firm, and thank you as always. Have a
Thank you,
good
and I
day.
appreciate the opportunity.
Centennial Elevators Industry versus JRM Construction Management. You may proceed.
Good afternoon. May it please the court, Carol Lambos, the Lambos firm, on behalf of the plaintiff appellant Centennial Elevator. Centennial is asking this court for de novo review of an extraneous document referred to as the JRM Master Services Agreement.
Was work done pursuant to the terms of this purchase order?
Yes.
Binding, so that you would concede that the purchase order is binding on the parties?
Yes.
And does the purchase order contain language that the terms of the purchase order and the MSA shall govern this work? So it incorporates, doesn't it, by reference?
We're asserting that it is not a lawful incorporation by reference. It does, and you quoted the precise language. It says, apply to the work, capital W. The MSA is a business terms agreement. The purchase order was a fully executed agreement that contained the plans, the specifications, warranties, price. The purchase order, the MSA is business terms. So under the Granini-Stone line of cases, an incorporation is for a specified purpose. Here, and JRM admits—
Didn't this purchase order reflect the parties' intent that the MSA would govern the parties' relationship until they formally executed the MSA, and that provided for an arbitration or mediation provision, mediation process before coming to court?
Well, the issue here is conflicting statements about the MSA. So in order for the MSA to be lawfully incorporated, you need two steps. One, identify the MSA. So the MSA, the lower court said the MSA was identified, but you also need assent to the extraneous document, and Centennial never agreed to the document. There was a signature block that was never signed. Periodically, when it was transmitted, JRM stated it had to be signed. JRM further stated if it wasn't signed, they wouldn't issue a purchase order or they wouldn't pay Centennial. Yet, the purchase order had already been issued and Centennial was paid for its work up to a certain point. So the issue is a factual issue whether Centennial ever agreed to that MSA. They never did. And the issue here that's really outstanding is in the transmittal email that was sent with the MSA, JRM stated, you can't make changes to the MSA. The purchase order addresses the terms and conditions of the work. So you have the purchase order itself said the parties will negotiate the MSA, and then JRM states the MSA is non-negotiable.
So it seems to me at that point, your client had one choice, either agree or walk away from the deal.
It wasn't an issue of walking away from the deal. They had already started to perform.
Okay, but if that is the condition.
But that wasn't the condition because JRM accepted the performance without the signed MSA. JRM periodically emailed and asked for the execution of the—
What about on August 9th,
yes,
2017, didn't the defendant email to the plaintiff a copy of the MSA and say, look, every subcontractor doing business with JRM is required to sign this master subcontractor agreement? So it wasn't like, what agreement is it? I mean, it was very clear. Didn't you know about that? And if you're going to do the work, you know, you have to send it back to us and you're obligated to follow its procedures. No, that wasn't what they did?
Well, yes, that's what that email said, but it was conflicting with the language of the purchase order that said, we'll negotiate the MSA. The email says it's non-negotiable. So what is the identity of the document? I would assert that the document's not properly identified. Is it a negotiable MSA or is it a non-negotiable MSA? And Centennial, the next phase is, in spite of the identification issue, and then I will also say it presents a third issue, the language you just quoted. It said that this MSA would exist in perpetuity for the parties' dealings in the future. My light is on.
Thank you. You'll have time on rebuttal. You may proceed.
Thank you. May it please the court, Janice Urbano with Clark Golden Attorneys at Law for defendant respondent
Counsel, how do you
JRM Centennial.
I'm sorry. How do you respond to your adversary's position that they didn't sign the MSA, so that's it, end of story?
Well, I submit that the signature actually isn't required because it was signed, the purchase order itself was signed, and there's no conflict at all with the purchase order and the MSA, and the language is very clear. On the very front page of the purchase order, in the last paragraph, it talks about the MSA. It states that the parties agree that they'll negotiate in good faith the MSA.
Well, so what
But
about, I'm sorry to interrupt you, but counsel indicates you did not negotiate at all about the MSA. So where does that change anything? You said you were going to, but she says you didn't.
Your Honor, I assert the exact opposite, and in our papers we detail the back and forth emails. So JRM sent both the purchase order and the MSA on August 9, 2017 to Centennial. Centennial responded. JRM responded again with a red line. Centennial responded a second time. JRM responded in September with another red line to those revisions, at which point Centennial, and Centennial admits, says, they're not acceptable, we're not going to get anywhere, and they abandoned the negotiation of the MSA in September of 2017. Centennial then begins work in February of 2018. Not only do they commence work, they perform for 23 months, nearly 2 years, and they are paid for the work that they do during those 23 months under the terms of the purchase order, which explicitly incorporates the MSA and not as a negotiated MSA. That language says that there will be, it does acknowledge that most parties will try to negotiate those terms, but it explicitly says the parties further agree that until such time, and notwithstanding the submission of any prior terms and conditions delivered to JRM from Centennial, the terms of the purchase order and the MSA shall govern. That's very clear. The MSA, as submitted to Centennial on August 9, 2017, are the business terms under which Centennial was operating unless and until there was some change to them. Centennial's the one that abandoned those efforts.
So was I correct that your adversary's client had the choice to not move forward on the deal?
Absolutely. They could have chosen not to sign the purchase order, and we would have found another elevator subcontractor.
Now, she argued that they had already started their work.
They did not, no, the purchase order and MSA were spent in August 2017. Work did not commence until February 2018.
Okay, so all of these, everything that is now being litigated was before them, before they began work.
That is correct, Your Honor.
Thank you.
Thank you.
Counsel, you'll have a minute on rebuttal.
Even if the MSA could be considered to be incorporated by reference, which we assert that it cannot, there would still be limitations on the MSA because the MSA could only be incorporated for the purposes. And the MSA isn't a redundant nullity because the language of the purchase order that said shall govern the work with the capital W. The work was the performance of the elevator modernization. It's not the business terms that were included in the MSA. So, as I said, the Guarini-Stone line of cases say that the incorporation must be for a specific purpose. Here, Centennial JRM admits that the purchase order governs the work and the MSA was business terms. So the language of the purchase order says it's only incorporated as it may govern the work, which by its nature, it did not govern the work.
Thank you so much.
Thank you.
AM Infant versus New York City Health and Hospital. You may proceed.
Good afternoon, Your Honors. May it please the Court, Diana Lawless for the appellant, New York City Health and Hospitals. Here, the Supreme Court erred when it granted leave to serve a late notice of claim. The key error is with the actual knowledge factor. The court wrongly understood that the medical records, which in any event the plaintiffs failed to submit with their motion, which fails in and of itself.
What caused the plaintiffs not to be able to put in the medical records? Was there some, did it take them, there were some issues with getting records? Hadn't they asked for records and there were issues with getting them?
Well, all that we know is that counsel said, I believe for the first time in reply below, and kind of made an argument about it now, that they had made a request and the request had not been responded to. However, that doesn't account for because the delay.
How does that not account for the delay? If they make a request and they don't receive the records from the Health and Hospital Corporation, how is that? I don't understand.
Oh, only because based on what they said is that there was only, they said that they requested them only, it could have been in some time 3 weeks before they made this motion. So they say that their client didn't
So if they were consulted shortly before they made the request, what's the problem? So if this woman who claims that she wasn't even aware that she was able to pursue a legal claim, finally encounters an attorney who advises her, no, you have a claim. And he then pursues, or she then pursues, subpoenaing the records and doesn't receive them, what's the problem?
Well, I'm just saying, Your Honor, that it's a large hospital system. It's a request of 3 weeks. We don't have any.
So bottom line is that you had the records. Right?
Bottom line is we put them in. They're in this.
So
they're in this
the
record,
records
right?
are
So
in,
setting
and
that
the
aside.
records we can, no matter which party puts them in, they're in.
Right, they're in now.
So you argue that there's no actual notice, but don't the medical records specifically point to a right side Erb's palsy with follow-up with neurology? Doesn't that suggest that the hospital knew that there was injury at that time during the birth?
Yes, but there's nothing that documents that there was a deviation from good and accepted medical practice. And
Except that this was an extremely large baby. And there is clearly a claim here that this was a woman who was prime candidate for a C-section in light of how large this child was. And indeed, the baby got stuck in the birth canal and had to be pulled out, hence the injury to the arm and the shoulder, correct?
Well, Your Honor, I would just say about the candidate, being a candidate for a C-section only comes from counsel's representation. But I will.
I mean, counsel, are you suggesting that in medical records it's supposed to say there was a deviation from standard medical practice? Of course not. I mean, they have the facts there that lead to the potential conclusion that may happen. I mean, you had the facts that you needed to know in terms of understanding something happened. Didn't you send the child for like immediate neurological follow-up after she was born?
Your Honor, all I will point to, I know I have time on rebuttal, but just very quickly that I think we're just following the Court of Appeals in Williams, the line from Williams, Wally G, and this court's case, recent case of MM from 2019 that I think is identical to this one, where there's nothing that shows an act or omission inflicted the injuries or an assumption that the child should have been delivered by C-section. This was something that they knew could have happened. They saw that it happened. They provided the information about how this is a complication that can happen, and there's no evidence that
And it's a complication that could be avoided if there's a C-section.
Well, Your Honor, we don't know that on this.
But you can tell from the last, I mean, look, a woman is in her last month before birth, you're getting a sonogram once a week in order to continue to test the size of the baby, how much amniotic fluid is left in the uterus, etc.
That was all done here, Your Honor. That's on this record.
Okay, which means that there are records that show that this was, according to the report, an exceptionally large fetus.
That is correct.
Okay,
But
so that to me tells me that there should have been an all-out discussion with this mother about the potential of the child not being able to fully deliver vaginally.
We know from the record we know there was consent for vaginal delivery. We know there was consent for C-section. We know that the risks were discussed with the mother. We know that this is the type of thing that could have happened. We know that it happened. But what we're saying is that it's obviously a hospital. Obviously, every procedure in a hospital comes with some risk. Births come with risk. That in the terms of here, we're at the stage of a late notice of claim, not litigating the malpractice itself, that having documents that just say, this happened, and there's a brachial plexus injury, it doesn't show that the hospital would be on notice that it was going to get sued for this, because it doesn't show that there was anything that happened that was wrong or different than what the hospital thought was going to be within the realm of possibility.
But isn't that really a defense to the malpractice action as opposed to a defense to the late notice of claim?
I don't think so, because it has to...
Because you're essentially, what you're saying, and I don't think the case to support it, is that they have to prove their case at this stage.
No, they have to prove that the records evince there was a deviation from good and accepted medical practice that comes from this court's decision in Cartagena, I believe. And again, this court's decision in MM is fully on all fours with this case.
All right, you'll have time.
Thank you,
It's
Your
an
Honor.
Erb's palsy case?
Yes, Your Honor.
Okay, all right. You may proceed, sir.
Good afternoon, Larry Rosenfeld for the respondents. May it please the court. This case involves a Erb's palsy case and an application for a late notice of claim.
Counsel, can you address the claims with respect to the mother? Was HHC on actual notice based on the medical records and evidence of her claims?
Of her, I didn't.
The mother's claims.
I'm sorry, I didn't.
The mother's emotional and mental anguish claim.
Okay, emotional injuries are the birth of a child with Erb's palsy that could have been prevented with a cesarean section.
Yes, but she's suing for emotional.
Yes.
Her independent claims.
Yes.
Not derivative claims, independent claims. How are they on notice of her independent claims?
Oh, they are not on notice. That is correct, but it's a derivative claim.
Well, the only derivative claim would be the loss of services claim, correct?
Correct.
So that's your only claim
Correct.
you're making? You're only making a loss of services claim?
Correct. And that's all. It's not
So you're abandoning the emotional claim.
I am abandoning the physical injury claim of the mother.
And psychological
All right.
injuries? Okay. And psychological injuries, correct?
And yes, loss of services claim.
Just the loss of services claim is all that.
Correct.
The derivative claim, okay.
All right.
Okay.
Okay.
So, so the GML Section 50, E5, provides for late notices of claim, and it states whether the hospital had actual notice of the essential facts. It's not all the facts, it's just the essential facts. So respondent is not claiming that in every case of a medical malpractice case that medical records provide the essential facts. We're just saying in this case it did, right? There was an actual on delivery, the injury was noted, and then and there's the pre-delivery records indicated that there was a large baby, as the court has already noted. The General Municipal Law also provides that in doing a late notice of claim, one of the first things they mention is to consider is whether it's a child or not, right? And which it is in this case. In this case,
Am I correct that the birth was in June 2020? So there was a year and 90 days to file a notice of claim timely, right?
Yes.
And you file
Yes.
it like less
Yes.
than a month later. So
Yes.
isn't that something we should consider too? I mean, it's really.
yes, the timeliness aspect, it was done, you know, first of all, we're not giving the medical records in a malpractice cases like, how do you, I'm between a rock and a hard place where do I make my motion when I get the records, or I make my motion before the records? I wait till a year and 90 days expire or don't expire? It's, where do you go first? So the delay was minimal. The argument about being expert opinions, those are not evidence. Those are, those are things that come at trials. They're not facts. They're just evidence. I shouldn't say it was not evidence. And lastly, the case I cited, Katchana, is in full support. In the case cited Williams by the appellant is misplaced, as cited by the lower court. And the case of Wally G is in opposite in the sense of that judge denied a late notice of claim, where in this case, the lower court granted the motion for a late notice of claim.
Thank you so much. We're out of time, but thank you.
Thank you. Sorry about that.
Counsel, no sorry necessary. You have a minute, counsel.
Thank you, Your Honors. Just to point out the timing, the notice of claim requirement is 90 days, so.
Right, but I mean,
Right.
I think my colleague was alluding to the 1 year and 90-day ability to move. Right.
We agree. But I would just say in terms of the timing on this, it wasn't, I know we discussed medical records and delays and all sorts of things before, but all that we have here is an affidavit from the mother who said that it was at some point that she realized that she needed to sue, and that was 11 months after the birth, and that at some point, 3 weeks between, if we read her affidavit together with counsel said it was 3 weeks. You had a 3-week window between knowing we were going to sue and making this motion. So the length of time where HHC didn't know it was being sued was 9 months after they would have received a notice of claim. That's what the timing issue is here. But again, we just reiterate that
Where's the prejudice, other than you're being sued for a malpractice claim you would have liked not to have? But where is the prejudice in your preparing a defense and handling this because of this very, very short time delay?
But sure, as Your Honors, you know where I'm going to go, which is that the Court of Appeals requires that there be some actual showing by the plausible argument by the plaintiff first. There's no arguments that they make at all on this, and the court did no analysis on it. They just tie it to the knowledge coming from the records or not, and we didn't have to put forth anything now because that's not enough. But we're saying that at this point, you know, it's later, it's not at the same time, we could have done things contemporaneously, but it was actually their burden. But we just want to reiterate that counsel's argument that an injury by itself noted on the records is not enough. Our argument is that it's not enough for actual knowledge, and we ask that the court reverse and dismiss the complaint for failure to serve the timely notice of claim.
Thank you. Desios versus Regent Associates.
Prize, well, not the prize, you got the second. Consolation. I think we can resolve it. Probably.
You may proceed.
If it may please the court, Alan Cohn for Appellant Sonomi, the undertenant. The heart of the issue is how to interpret Great Northern and its appropriate case law. Great Northern says straight up that if there is an insurance requirement, if there's an insurance procurement requirement in a lease coupled with a indemnification provision, then the indemnification provision is valid. Otherwise, it is invalid. That is mandatory language. It has to be insurance procurement requirement in the lease. It doesn't say anywhere that if the tenant happened to purchase, tenant happens to purchase insurance on its own violation for its own reasons. In the present case, Your Honors, there was no insurance requirement provision in the lease. This is a three contract languages. The first one to the second one had an indemnification and insurance requirement. When it went from the second, meaning the undertenant or the overlander, to the next one, the sublease, it specifically modified the contract language to get rid of the insurance requirement. So although the overlease had insurance requirement.
Did it get rid of all aspects of the insurance requirement or only a part of it?
What the language says is, Your Honor, is that they shall, at their sole option.
Just answer my question. Did it alter all aspects of the insurance requirements or only as to a part of it?
It altered all mandatory aspects, Your Honor.
So both as to general property and as to bodily injury?
Oh, no, Your Honor. So it fully altered aspects, all aspects of bodily injury. And to address Your Honor's question.
Where does it say that?
12.13, Your Honor.
But wasn't that modified by 18E?
Correct, Your Honor, and it modified it by stating that no longer does the tenant have to purchase insurance. Instead, the landlords, at their sole option, shall purchase insurance. So on the original lease, it said the tenants must purchase insurance. It's the original lease. And then the 18E says no.
And that original lease was between Regent and St. Nicholas?
Correct, Your Honor.
And then the second lease was between St. Nicholas and
1439, Your Honor.
Yeah, 1439.
Then assigned it to my client.
Okay, and then 1439 to, how do you say the name? Sonomi. Okay.
Yes, Your Honor.
All right.
So because the language, like Your Honor said, because you just pointed out the language says at your sole option, there's no mandatory insurance requirement. Great Northern stands for the parties execute an agreement or a contract, thereby to use insurance to basically assign the risk to an insurance company over the parties. There did not happen in this case. This is just.
Who did Sonomi pay pay rent to?
They pay, it goes in effect over to Regent.
And when they
It's sort of in the
paid,
middle there.
when they paid the rent, did that include that 60%?
60% of the insurance cost?
As additional rent?
We say so, there's obviously a subject to factual disagreements as to that. But what is clear is what is clear is, Your Honor, nobody purchased insurance for us from the landlord's perspective, and there is no mandatory insurance requirement.
So, wait, did your client obtain its own insurance coverage?
Your Honor, two answers to that question. On the facts and on the law, we obtain our own insurance coverage for ourselves. Obviously, my bills are being paid by insurance company for defense. That does not imply that we have insurance coverage to defend a third party, meaning the Regent or the Overlander.
So is the answer to the question, did your client have insurance? Yes?
For itself, yes.
This is not a,
No, Your Honor.
We're not at trial. This is not a trick question, okay? We need the answers to our questions in order to decide. So trying to kind of
No, I'm not
move
trying
the shell doesn't help you.
I'm not trying to be evasive, Your Honor. We had insurance for ourselves. The scope of that insurance is subject to an entirely separate lawsuit that's not before the court under a different index number.
But the issue is not whether it applies to another index number. The question is whether that policy, whichever policy you're referring to, applies here. And I don't have to take your word for it, with all due respect.
Yes, Your Honor, there is no insurance policy in the record. There's no affidavits. There's no deposition testimony showing we have insurance policy for this type of lawsuit with regard to Regent. And I would point out, Your Honor, on the legal perspective, even if we had an insurance policy, we went out and purchased that insurance policy on our own without a contractual obligation to purchase that policy. That does not, under Great Northern, make the lease valid. The question in the Great Northern is whether there was a contractual...
Isn't there an exception to Great Northern that they argue is applicable in this particular case?
Which exception, Your Honor? Pardon me.
Well, there's...
Usually the questions don't go this way. So
No, there's no exception. There's no exception, Your Honor, applicable, no. The Great Northern, what we court may be referring to is there are some cases, law, which we cited to, that says if there is an insurance policy which is basically meaningless or didn't actually get purchased or for whatever reason doesn't cover the cases or whatever, if the insurance policy is meaningless, then the insurance policy does not comply to the Great Northern exception.
Thank you. You'll have time on rebuttal.
Thank you, Your Honors.
Good afternoon, Your Honors. Joel Simon from Smith Mage on behalf of Regent Associates. As appellant, very briefly, the lower court erred in that when they granted contractual indemnity, they didn't reference attorney's fees and costs, which clearly from the provisions we're entitled to. Now, as respondent, it's their position that Great Northern does not apply. They are wrong for two reasons. The first is that Great Northern does apply. Great Northern does not require additional insured coverage. Great Northern requires that the risk is allocated for insurance. There is no
But the risk has to
dispute
be
here.
allocated in the contract, doesn't it?
I'm sorry, Your Honor?
Doesn't it have to be allocated in the lease agreement?
No, Your Honor. In fact, I'm going to reference Great Northern, which dealt with an entity called depository, which is the same type of entity, let's say, as Sonoma is, where they're the tenant, the entity that provides the indemnification. It says depository's insurer, not depository itself, will bear ultimate responsibility for the indemnification payment, which is precisely the result contemplated by the parties when they entered the lease.
That's it. So it's got to be in the lease.
The
That's
lease
exactly
is
what you're
assumed.
saying.
Your Honor, Sonoma assumes all the obligations from the prior leases.
So then it's in the lease.
It wasn't, I'm sorry, it wasn't in the modification agreement.
Okay.
But it was in the portions of the lease they assumed. Okay. They have insurance. St. Nicholas, for some reason isn't here, had insurance.
But 18E, which is the clause that we're talking about.
Right.
18E basically says,
oh, that's
you're
the
going to be
second.
charged additional rent, and you don't have to procure insurance. The landlord is going to get their own insurance. Isn't that what 18E says?
Well, Your Honor, actually, that's why I said there are two grounds. The first, assuming they are correct about 18E, which they are not, but assuming they are, Great Northern still applies because, again, they have their own insurance. However, if...
Did you have an obligation under any of these lease agreements or modifications or riders to, an obligation to obtain insurance coverage for them at your option?
Well, 18E modifies
18E.
12.1.1
Right.
to 12.1.3
Right.
as regard to premises liability, not premises insurance, not liability insurance. It specifically notes.
But 12.1.3 refers to bodily injury.
It also refers to boiler and machinery equipment.
It does, but
And then-
18E doesn't say anything regarding, it only says that 12.1.3 is going to be modified and that you're going to charge additional rent.
Actually, Your
And if
Honor,
they pay that,
it
then
says
you
more
pay
than
your own
that.
insurance.
Well, counsel, I have it right here. It says, with respect to the subparagraphs 12.1.1 and 12.1.3, comma, undertenant agrees that the insurances coverages referred to shall be purchased with respect to the entire premises, and that either overtenant or landlord shall, until further notice to undertenant, and at their sole option, purchase such coverages. So it refers to all insurance coverages referred to in paragraph.
With respect to the premises, Your Honor, it's the premises insurance. It's not liability insurance. It's
arguably,
property
I'm
damage
sorry, Let me
insurance.
stop you for a second. We're having this discussion. Could one argue that there's an ambiguity in the provision as to how it applies, and that's an issue for trial?
Well, Your Honor, I don't think it's an ambiguity. It specifically notes in relation to the premises. That's property damage, Your Honor. It's not liability insurance, and the fact still remains.
But liability insurance covers things that happen on the premises, no?
But it's not
So
premises
is, so
insurance.
is,
There's a difference, Your Honor.
you're saying property insurance.
But, Your Honor, I'm also going to jump to the point that even if that's correct, it's not relevant because they still had their own insurance which covers the risk.
See, but that's insurance for them. The issue is whether they had to include you on it based on the 18E
Actually, Your Honor,
modification.
that's not what Great Northern states. Again, in Great Northern, the entity depository, which is the similar entity as Sonoma would be, the tenant, the entity that owes indemnity, the court rules that the contractual provision is proper because depository, i.e. Sonoma's, own insurance carrier is covering the cost of the indemnification.
I don't recall Great Northern having a similar factual issue where here, one of the modifications said that the landlord, that they would pay an extra fee in rent in order for the landlord or the first tenant to cover the insurance.
Your Honor, respectfully.
Was that in Northern?
No, that was not, Your Honor. And
So that's a different factual.
But it's not a relevant difference, Your Honor,
Well, that's for
respectfully.
us to
Respectfully.
determine.
And
Thank
if
you.
I may, for 30 seconds more, Your Honor.
30 seconds.
The point in the Great Northern was, is there an entity that covers the indemnity obligation? In Great Northern, it was the entity who owed the indemnity, the same as Sonoma. Sonoma has its coverage. Whether or not we were to be named or name them is not relevant. The question is there a policy that covers that obligation? And yes, there is, Your Honor.
Thank you. Counsel, you have a minute.
Very briefly, Your Honor, to address 2 points. First of all, 12.13 specifically states death. Over here, we're talking about a plaintiff. Plaintiff is the family of the decedent. So 12.13 specifically concludes this without a doubt. In addition, we're talking about the wrong part of Great Northern. The language that's relevant in Great Northern is, quote, significantly, the lease also contained an insurance procurement provision, directing the tenant to name the landlord as additional insured. Similar language is 2 other times in Great Northern. Great Northern clearly holds and states that the reason why it's coming to its conclusion is because there is a mandatory insurance requirement under the terms of the lease. If the court has no further questions, I'll yield the remainder.
Thank you.
Thank you, Your Honors.
No?
I actually did, Your Honor, as cross appellant.
Yeah.
Go ahead.
No, I was simply going to say, Your Honor, that unless the court has any questions further.
Really, you stopped me for that?
I'm sorry. I'm sorry, Your Honor.
That's rude.
I didn't mean it to be rude, one. I
Well,
apologize.
you were. Have a good day.
Thank you.
People versus Olivieri. Did I miss one?
No, that's it.
You may proceed.
Thank you. Good afternoon, Simon Greenberg on behalf of Appellant Jorge Olivieri. The district attorney's decision to file the bail jumping indictment was a vindictive prosecution in violation of due process.
Counsel, they had probable cause, and you're not denying that they had probable cause that the defendant bail jumped. So how is it vindictive?
Well, you're right, Your Honor. We don't, I mean, he pled guilty, so he pled guilty to bail jumping. But the vindictive...
But he pled guilty because he failed to return when he was required to.
That's
And it was a legitimate charge under the law.
Well, Your Honor, the vindictive prosecution doctrine applies even when, it applies precisely when the prosecution has an improper motive for bringing charges when the charge might otherwise be legally proper.
If I understand this correctly, here, there was a ruling that your client attempted to file a motion in order to have it reviewed because of case law that came down after his plea, correct?
That's correct, Your Honor.
And in the interim, while the court was sub judice considering that, the case was put back on the calendar and your client voluntarily failed to appear, correct?
That's correct, Your Honor.
And a warrant was issued.
That's correct.
And that, therefore, on the basis of just those facts, warranted and certainly gave the people the absolute authority to file a case for bail jumping. Am I right?
It gave them the authority to...
They could have done so before he even returned back to court, right? Am I right?
Yes, they could have filed the bail jumping indictment, Your Honor, but not for the purpose of vindictively prosecuting him.
Well, you say vindictive. They say that your client gets returned to court, and they say, look, we clearly have another bail jumping charge that we can lodge, but we don't have to do that if you just withdraw your motion and proceed. Why is that vindictive?
Well, what happened here is that the Gold decision in the Court of Appeals, it invalidated...
I started with that, yes.
Yes, Mr. Olivieri's conviction for aggravated family offense. The people are...
Well, it didn't invalidate the conviction. It ruled that portion of the penal law unconstitutional, right? There's a difference.
That's what Gold held, yes, that portion of the penal law was unconstitutional, but the trial judge ruled in Mr. Olivieri's favor that he couldn't be prosecuted for the felony aggravated family offense once Gold was decided. And the people are saying, we're going to file this additional charge against you unless you agree to keep this constitutionally invalid conviction, which is,
Well, we wouldn't be here if your client had just come back to court, right?
That's true, Your Honor.
He could have won his motion, which I believe he was well on the way to win, and then move forward from there. He chose voluntarily to disobey the order of the court and return. Why should the people have their hands held to a legitimate claim simply because the one before he rightfully asserted you can't pursue this anymore and this should be overturned?
Well, the people are trying to coerce my client into agreeing to keep an invalid, constitutionally invalid conviction on his record. That's what makes this prosecution for bail jumping vindictive. If they wanted to just go ahead and...
Counsel, would it have been vindictive if the people just indicted him without making a plea offer?
I think that would be a different case, but here...
Is that what you're asking for? I don't think that's what defendants want.
I'm sorry?
I don't think that's what defendants want. I don't think that defendants are in a position to prompt or egg on the prosecution to go ahead and indict them on additional charges when you could instead resolve everything with a plea bargain.
Well, but this wasn't a valid plea bargain, Your Honor, because the people are saying to my client, you have to agree to keep this, as I've said, constitutionally invalid conviction, or else we're going to come at you and double your sentencing exposure.
I have a question. Wasn't he indicted before the judge decided to invalidate the conviction?
Yeah, it was a few days before, Your Honor.
Oh, he was indicted before. So the people didn't know what the court was going to decide at the time that they indicted your client. They had no idea.
Well, that's true, Your Honor, but the people's threat here was, unless you agree to keep this conviction on your record, and ultimately, the people did not appeal that judge's decision.
So basically, they're plea bargaining with your client. They say, listen, if you don't make me work, if you don't make me go to the grand jury, I'll leave the bail jumping charge alone, and we just, leave it at that. But if you are going to make me answer the motion, then I'm going to go to the grand jury and indict you. I don't know what the judge is going to do, but you're going to have another indictment on you, and then we'll take it from there.
That's what the people said, that was their rationale for this.
It's their discretion whether or not to proceed with whatever charge they feel there's probable cause for them to charge.
They have discretion to proceed on a charge where there's probable cause, Your Honor, but not when they have the improper motive of retaliating against their client.
So basically, what you're objecting to is the fact that they try to bargain with your client, and they went ahead and they indicted him anyway.
Well, we don't characterize it
Well,
as
that's
a
how I
bargain, Your Honor.
characterize
It's a retaliation for attacking a constitutionally invalid conviction. And that's why what the people did was not something they had the authority to do here.
Thank you. You'll have time on rebuttal.
Thank you.
All right. Counsel, you may proceed.
Good afternoon, Your Honors. Nathan Scher for the people. May it please the court. Many of Your Honors have made many of the points that I intended to make, so I'll try and keep this brief.
Counsel, by couching the plea agreement in terms of saying, if you withdraw your pending motion, we won't bail jump you, aren't you in essence punishing him for exercising his right?
No, Your Honor. It's just a normal negotiation. Here, defendant, as has been stated many times, there's no question that the people have probable cause to seek the indictment for second-degree bail jumping in this case. And when they had that, as one of Your Honors stated, they wanted to strike a deal with defendant and not have to go to the grand jury and put the grand jury through this in exchange for having the defendant withdraw his motion to withdraw his guilty plea. And
another thing I want to point out, we've been talking about the defendant failing to come back to court. Obviously, that's what led to the bail jump charge. But before that, if I read this correctly, this case was a repleter, right, with the program, and wasn't he discharged from that program?
Yes, Your Honor. And so the fact that a normal, ordinary charge came after unsuccessful negotiations with the defendant didn't turn that ordinary charge into a vindictive one. And so nothing that happened here made the people's decision vindictive. And just one thing that I would note is that in any event, defendant loses on the merits. This court doesn't even need to reach the merits because the Court of Appeals has made clear that where a defendant pleads guilty, he forecloses appellate review of his vindictive prosecution claim. And that's what happened here. And if there are no further questions, we rely on our brief.
Well, counsel, now that you brought up that point about waiving this claim, isn't there also a federal case where they said that the plea of guilty does not foreclose the claim, at least in the habeas corpus proceeding?
Your Honor, that case is a very unique and specific case. I assume you're referring to Blackledge. And in that case, there was a statutory scheme where the defendant, where a defendant who was convicted of a plea, or a misdemeanor in North Carolina could appeal that conviction and receive a de novo trial. So the United States Supreme Court ended up ruling that the reason that that claim survived his that defendant's guilty plea was because it went to the power of the prosecutor there to bring the charges. Where here, as many of Your Honors have stated, these are separate crimes. The people could have brought these charges irrespective of whether defendant won the motion in his separate case or whatever happened in that case. And so that's why that case is inapplicable here.
Thank you.
Thank you.
Well, I.
Counsel,
one-
your claim of
I'm sorry.
vindictive prosecution, isn't that waived? It's not preserved, is it?
It is preserved.
How?
It's preserved because Mr. Olivieri, on the record in court, said.
He said that it was blackmail?
He said it's.
So you're expecting a trial court that when the defendant speaks out of turn, a represented defendant, and says something of that sort, so now the trial court's supposed to stop and issue a decision on the defendant's off-the-cuff comment that this is blackmail?
Well, I mean, I understand your point, Your Honor, but the judge actually did issue a decision. The judge decided the claim on the very same grounds that the people are actually asserting in this court. So under the CPL 470.05, Mr. Olivieri's case squarely satisfies the requirement that the judge actually decide the issue that's specifically in front of the appellate court. And also, Mr. Olivieri, obviously speaking as a layman, made the basis of his claim very clear. He put all the relevant facts on the record. He said they're retaliating against me. Well, I don't know if he used the word retaliate, but he said they're blackmailing me for exercising my constitutional rights. I think that squarely sounds in a vindictive prosecution claim. And the distinction, if I can finish, Your Honor,
Go ahead.
that my adversary makes about Blackledge is not actually, that there's not a distinction that the Supreme Court has ever drawn. If a claim is asserted as a vindictive prosecution claim, then it survives a guilty plea. The people's position is this was valid plea bargaining. That's an argument as to the merits. It doesn't mean that the court can't reach the merits. If a claim is framed as a vindictive prosecution claim, Supreme Court case law squarely holds that it survives a guilty plea. And the Court of Appeals decision in Tiger cited all of these Supreme Court cases for the proposition that there's a set of claims that survive guilty pleas, the Mena-Blackledge doctrine. So the Court of Appeals has very recently acknowledged all of these cases from the Supreme Court about vindictive prosecution claims surviving guilty pleas.
Thank you.
Your
We're
Honor,
out of
thank
time.
you, Your Honor.
Thank you. Intrepid Investments versus Selling Source. You're welcome. Have a good day.
May it please the court, I'm Jason Corral here for appellants. I wish to introduce Mr. Elliot Shirker, who has been admitted pro hoc vice in this matter. If may it please the court, I'd like to respectfully request to be allowed to argue the appeal for appellants.
Your motion is granted. Welcome, sir. I'll dispense with my little routine. You may proceed.
Thank you, Your Honor. May it please the court. The first question presented for the court's consideration is whether Section 7.06 of the White Oak Agreement, also called the WOA, breaches the intercreditor agreement, the ICA, by prohibiting selling source, which is Intrepid's debtor, from making payments on the Intrepid note. This court's prior decision in this case holds that a breach of the ICA by White Oak would allow Intrepid to sue on the Intrepid note.
No, so counsel, I'm not, I just have a couple of questions on these issues. It's basic contract law that you cannot have a breach of contract claim without damages. So let's assume, for argument's sake, that Judge Cohen is wrong and you've asserted some sort of breach. What are your damages? Because you can't get paid until the senior debt is paid. So what are your damages in these circumstances, and how do you have a valid breach of contract claim?
Your Honor, let me set the table. We raised the breaches of the ICA in response to the defendant's summary judgment
What
motion,
are your damages?
which invoked the standstill provision
Counsel,
we are-
counsel, what are your damages? I just want a basic answer. What are your damages, even assuming there's a breach? You would be entitled to your $28 million before the senior debt is paid?
We would be entitled under 2B to be paid, yes, 2B.
So in other words, we're going to flip the priorities. You're going to go from the third level priority to the first. Isn't that in contravention of the ICA?
Your Honor, respectfully, that's not what I said. 2B says specifically that selling source has a right to pay us, and we have a right to receive as of the Intrepid note's maturity date. The standstill provision is over here. The standstill provision says that we cannot bring an action so long as the senior debt has not been paid. But what this court held in Intrepid 1 is that if White Oak breached the ICA, the standstill provision goes away. So the question before the trial court was not a claim for damages on our part in this action. The question before the trial court was whether the other side could invoke the standstill provision, and that's why the breach of the ICA is key. And that's why the provision in the White Oak Agreement in Section 7.06, which defines the Intrepid debt as a restricted payment and prohibits selling source as selling source.
Where does it say that? I read the provision. Where does it say what you're arguing?
What the White Oak Agreement says.
Go ahead.
What the White Oak Agreement says, Your Honor, in so many words, at record 571 and 577, is that so long as any obligations, and that's a defined term, obligations means the senior debt, have not been repaid in full, borrowers shall not directly or indirectly do any of the following. Borrower is selling source. Section 7.06 at page 577 says declare or make any restricted payment. And a restricted payment is defined at record 531 as any payment of principal or interest with respect to any debt which is subordinated to the payment of the obligations. As Your Honor just noted, the Intrepid debt is subordinated to the first and second priority debts. So the White Oak Agreement specifically prohibits selling source, I would note, as selling source admitted in its answer at record 101 to 02. Selling source admitted that it had not paid the Intrepid debt because the senior lenders would not allow it. And that's the reason that the debt wasn't paid, was specifically because of the White Oak Agreement. What the ICA does in Section 2 is to subordinate third priority obligations, which is the Intrepid note at record 198, to payment in full of the first and second priority obligations, which was all well and good, Your Honors, and negotiated by Intrepid. But the Intrepid note has a June 2013 maturity date that was incorporated into the ICA, and Section 2B, which I just noted, specifically says that selling source, quote, shall have the right to make, and Intrepid shall have the right to accept, this is record 198, quote, payment of the third-party obligations as provided in the Intrepid note. And ICA Section 7 states, quote, nothing in this agreement.
But still, you can get those payments, Intrepid can get those payments, even if the first priority and second priority lenders have not been paid?
Absolutely, Your Honor. That is exactly what Section 2B says. And that is exactly what the White Oak Agreement took away by prohibiting the payment as restricted. Otherwise, Your Honor, Intrepid would be completely at the mercy of selling source as to when and if it would ever decide to pay. And in fact, we have never been paid.
Yeah, I mean, look, very often the third priority lenders don't get paid. I mean, I learned that I would never want to be one if I ever had to be a third priority lender because you're never going to get paid. So if these people are not going to get paid for whatever maturations have gone on all these years, I just don't get, I mean, I'm sort of going back to Judge Singh's first question, like how you ever could get paid before them, and so are we just all spinning our wheels here?
Not at all, Your Honor. Selling source tried, as the extrinsic evidence shows, to get White Oak to modify Section 7.06 in the January 2013 version of the White Oak Agreement, saying, please insert in 7.06 that we can make payments to Intrepid. And White Oak refused. It refused again after the White Oak Agreement was negotiated and signed. And Selling Source says at Record 101 to 02 in its answer that the only reason it didn't pay the Intrepid note was because the senior lenders wouldn't allow it. And again, I refer the court to Record 198, ICA Section 2B. Selling Source, quote, shall have the right to make, and Intrepid shall have the right to accept, quote, payment of the third-party obligations as provided in the Intrepid note. So we have a right to accept payment that Selling Source has a right to make, and the WOA took that away. That's a breach. The standstill provision doesn't apply any longer, and we can bring this action.
Thank you so much. You'll have
Rely on
time
a brief for the
rebuttal.
remaining issues. Thank you, Your Honor.
Okay. You may proceed.
May it please the court, Mark Hatchmiller for the Selling Source defendant. As Your Honors have pointed out, Intrepid is a junior lender. It's a third priority lender, and it's sued in violation of an intercreditor agreement. And not one of Intrepid's 4 pleaded theories of prior material breach of the ICA was borne out by the evidence. And that's the really important difference between the prior appeal, which was affirming the denial of a motion to dismiss. Now we're talking about the summary judgment record. As Justice Singh asked, what's the damages? So my opponent explained that their theory is if there was a material breach of the ICA.
Well, we found that. We found that in the, so we live with that decision. That's
Correct.
what we found. So,
Correct.
So in light of that decision.
In light of that decision, the breach has to be material, and there has to be evidence of a breach. So the question, what is the damage, does matter to the question of materiality. What we've really got here, to be totally frank, Your Honor, is we produced thousands of pages of emails and various contracts, and the plaintiff is basically searching for something in these documents that they can explain as a reason to bring the suit. None of it caused any harm, however, because of the basic scheme, which was that Intrepid does not, as a practical matter, get paid until the senior lenders are paid
What
off.
about counsel's argument that under Section 2 of the ICA, they would be entitled to payment?
They are not entitled to sue for payment, Your Honor. That's the issue. Unless there was some collusion, a material breach to prohibit payment, there's no excuse for suing early. And as to the alleged breach, I'll focus just on 7.06. What you found in the prior appeal was that it was ambiguous whether that provision was intended to prevent payment to Intrepid. The language, I think, as the lower court judge said, it was sloppily drafted. It was somewhat confusing. But there's nothing explicit in it that says Intrepid can't get paid. So you'd expect to see now at the summary judgment stage, after all these emails and everything else were produced, that the plaintiff could point to you somewhere in the negotiation history that's where there's an email or a document that says, no, you can't pay Intrepid. There's nothing like that. What they point out is, at one point, my client, Selling Source, which is the borrower, very clearly said, we need the right to pay Intrepid. And we want to change 706 to have a right to pay Intrepid. In response, White Oak didn't change 706, but it did change another provision, 8.01n. And in 8.01n, there was a previous version of 8.01, as my opponent points out, but it was changed in the final version to specific.
Are you talking about the final version of the intercreditor agreement or of the White Oak agreement?
White Oak agreement. The January 2013 version, which is the version they say it was a breach for Selling Source and White Oak to enter that agreement. It explicitly says Selling Source can pay Intrepid. Not only can it pay Intrepid, it must pay Intrepid 45 days early, or else it's in breach of the senior debt. So, Your Honor, Justice Singh, to your question, what's the harm? There's no possible material breach where the agreement that they're complaining about required Selling Source to pay early. If the court has nothing further, I believe.
So why, but you didn't pay. Obviously, that's why we're here.
Correct, because the senior lenders haven't been paid off yet, and until the senior lenders are paid off, practically speaking, Intrepid can't sue. there is.
Yeah, but we're beyond that, because we have a motion, we made a decision on a motion to dismiss, and we said that the standstill provision, if there was a material breach. So again, so your argument essentially then is that there's no material breach because they're never able to show damages.
No, the argument is, you said there would be a material breach if Intrepid found evidence. You said there was an ambiguity with regard to 7.06. Does that provision prevent payment to Intrepid? It was ambiguous enough that Intrepid opened the door to get discovery. It got lots of the discovery emails to find some intent that this provision was intent, which doesn't say explicitly that Intrepid can't be paid, but they got to search for evidence to support their interpretation of an ambiguous provision. They didn't find any such evidence, and so Justice Cohen correctly found at the summary judgment stage, there's no evidence to support the interpretation that Intrepid.
I have one more question. Go ahead. Now, on another breach that's alleged is the change of the maturity date of the junior loan, you argue in your papers there was never a change, it's a matter of contract, but clearly they should have been paid in 2013, right? They haven't been paid today. So isn't there, wasn't there an extension in some fashion, mostly because the senior debt wasn't paid, right?
No, Your Honor. When a debt doesn't get paid, it might have not been paid, and because of this intercreditor arrangement, Intrepid is not yet allowed to sue over the non-payment, but the fact that a debt doesn't get paid on the maturity date doesn't mean the maturity date changed. Thank you.
Thank you. Okay. You may proceed.
Thank you, Your Honor. Neil Omarachu for White Oak Global Advisors. Going back to the White Oak Agreement, I think that as the White Oak party representative explained at deposition on page 1719 of the record, and as the court below accepted on page 17 of the record, the language of the White Oak Agreement is unclear, but it did incorporate by reference the priority structure of the intercreditor agreement. Because what the intercreditor agreement said is, although Intrepid's debt is subordinated to White Oak's debt, the payments of Intrepid's debt are not subordinated to White Oak's debt because Intrepid retains the right to receive those payments. And we believe, and there's no evidence to the contrary, that White Oak intended for that provision to remain in effect, and that language is still in effect, because it talks about not subordinated debts, but subordinated payments, and the payment of the Intrepid debt, the payments on the Intrepid debt are not subordinate. I also appreciate the court's questions about what it is that the Intrepid lost. There is no material breach here. The bargain that Intrepid made was functionally that first the senior lender would get paid, and only then Intrepid would get paid. The senior lender hasn't been paid, so Intrepid really hasn't lost anything. There's certainly no evidence whatsoever in the record that this White Oak Agreement was the but-for cause of Selling Source not repaying Intrepid. There's some stray language in Selling Source's answer, a legal conclusion that our brief addresses in some detail, but the key thing to note about that is that it is only White Oak, not Selling Source, that has the ability to breach in such a way that the remedy standstill is no longer in effect. And our brief at footnote 6 provides a long list of cases saying that nothing that Selling Source does can waive the priority.
So the material breach is on your part, the alleged material breach that would be relevant here would have to be something that White Oak did.
That is correct, Your Honor.
And they claimed a few material breaches. There was something with the Katara sale?
The Katara lien,
Was that
yes.
something with the lien, about releasing the lien, you allowed it to be released? I mean, do any of those things rise to the level of material breach?
For example, with regard to the Katara lien, Your Honor, this was a subsidiary of Selling Source that was merged with another entity, and as part of the merger, we released both our liens and the junior liens to allow that.
And you had the right to release the junior liens?
We do. Now, they argue that it is not a bona fide or a valid sale,
right.
But the contract also covers disposition of the collateral, and their argument is, well, Selling Source retained some ownership interest in the new entity, but there's no argument whatsoever that White Oak retained any ownership interest in the new entity. And to the extent that Selling Source had an ownership interest, that ownership interest is, again, subordinate to their junior standing, available to them for repayment of the debt, right? Anything that White Oak, they say, well, Selling Source retained some interest after the Qatar deal, but any interest that Selling Source retained is common collateral that is still available for repayment of the senior debt. So again, there was no material breach by White Oak here. We didn't deprive them of anything that would have made it more likely for them to get paid. We didn't prevent anyone from paying them.
So in other words, counsel, I think what you're arguing is that the only basis, and you say that it's not, is the breach has to come from the White Oak Agreement. It's nothing what Selling Source did and what Intrepid did. Is that correct?
Right. And the White Oak Agreement didn't materially alter the benefit of the bargain. Regardless, and we've explained, I think, the judge below accepted the correct reading of the White Oak Agreement. But even if you accept their reading of the White Oak Agreement, it doesn't change the basic priority scheme. It doesn't deprive Intrepid of the real benefit of the bargain, which is, as the court said, you know, if you're the third lender, you don't get paid until the first and second lenders get paid. And that's just how it works in commercial lending. Unless there are any further questions, thank you.
Thank you. Okay, sir, you have time on rebuttal.
I was listening very carefully to the argument that White Oak's counsel made, and he specifically said that Intrepid's right to be paid was not subordinated. And as unusual as it is in this hotly contested litigation, I entirely agree, because that's exactly what I said in my opening argument, that 2B gives Intrepid a right to be paid regardless of the subordination.
But not before the first and second priority lenders.
No, Your Honor, respectfully, 2B gives us a right to be paid irrespective. A right to be paid, not a right to sue.
I'll look at that. I don't, that's not how I understood it.
Your Honor, let me again refer you to 2B of the intercreditor agreement. There is nothing that conditions our right to be paid on payment of the senior debt.
But doesn't that provision essentially say that the note can be enforced? I mean, are we talking about the same thing?
We're not talking about a right to sue. The question whether we have a right to sue before the senior debt is paid is the threshold question in this case, and the question that this court addressed in Intrepid 1 when it held that if White Oak, and we agree it must be White Oak, if White Oak breached the ICA in the White Oak agreement, then the standstill clause goes away and we have a right to sue. But the question that we were discussing during my opening argument was whether subordination is subordination of the right to be paid. And you heard White Oak's counsel admit just exactly what I've been saying, that there is no subordination in 2B of the right to be paid. So the question is, did the White Oak Agreement, by defining a restricted payment in section 7.06 as payment to Intrepid, breach the ICA by essentially subordinating the right to payment for the first time in contravention of the ICA?
Thank you.
Thank you.
Lawrence Capital versus Axis Insurance. You may proceed.
Good afternoon, Your Honors. James Saratella on behalf of plaintiffs' appellants. May it please the court. This case concerns an insurance company's attempt to add an exclusion to a renewal policy in a way that not just violates business morality and decency, but violates the express provisions of New York Insurance Law 3426. Now, there is no doubt that in 2018, Axis added an exclusion to the policy on renewal without complying with Section 3426. It did not tell Florence it was adding the exclusion. It did not say what the exclusion was going to do.
So what's the remedy, counsel?
The remedy is that the exclusion is not enforceable.
For how many policy cycles?
It is not enforceable until Axis corrects its mistake.
What case law says that?
The Axis case is squarely on point, Justice Manzanet, and that's a second department case.
You know we're not in the second department, right?
I understand that.
Okay.
But that court looked at the statute, which provides very plainly that, quote, a covered policy shall remain in full force and effect pursuant to the same terms and conditions and rates if Section 3426 is not complied with. And the lower court...
But for another required policy period, right? Aren't you missing that language?
Yes. Now, if you look at the Essex decision, and this is on 689, the court says...
So in other words, your argument essentially is that there's perpetual insurance.
It's not perpetual insurance, because all the cases that deal with perpetual insurance, they're about cancellations of policies. Policies were, for the most part,
Well, okay, in this case, the exclusion never applies, essentially, right?
Well, here, what you have, Your Honor, is a policyholder that purchased insurance with no exclusion, and then the exclusion gets added. That reduces 60% of their business, and the premium stays the same. They're not told about it. And what the insurance company is arguing is that that's okay, or that's maybe not okay for 1 year, but after a year, it's okay. We violated the statute, we're off the hook.
Well, that's what the insurance law seems to say.
Well, it doesn't say that, actually, because, and let's just think about this for 1 minute. If that were the law, it would invite insurance companies in New York to basically ignore the statute, because what would be the harm in doing so? You're only on the hook for 1 year. And if in the Essex case is squarely...
You're not presumed to ever read your policies?
That is correct. That is what the not the initial policy, but on renewal, you're not expected to.
You're not expected to. Okay, really? But so in this particular case, you did have insurance brokers who were also defendants in this case, correct?
Correct.
And you said to the insurance broker, hey, here's my insurance, you know, is this okay? Does this cover everything? Is everything okay? And from what I could tell in the record, Axis wrote new provision, like, you know, they weren't really trying to hide it or sneak it in. They were actually telling whoever was getting that, you know, we're putting in a new provision. So, I mean, you seem to have a claim against your insurance brokers.
Right, Justice Katnick, but if you look at the statute provides...
I'm looking at the statute.
I'm looking at the statute.
Right, the statute provides...
Well, we're all looking at it, but I thought it said for another required policy period. So for 1 year, you're right, but for 3 years, you're not right.
Well, first of all, the statute says that you have to give notice to both the policyholder and the broker.
That's correct.
Which is why you get the extra year.
Right.
So now what do we do with 2020? Because 2019 is covered based on your argument, but not 2020.
But if you look at the Essex case, because what happened there was a reduction in coverage, and the court says that since no notice of conditional renewal was provided any time thereafter, after the first renewal, the same coverage, including coverage for the Lynn defendants as additional insureds, remained in effect throughout the coverage period from March 26, 2005 through March 25, 2006, as well as what was in effect on June 25, 2005. So in the Essex...
But I'm reading another quote from that same Essex case, which said it remained in the coverage for the period that they were talking about, remained in effect on the same terms and conditions of the expiring policy for another required policy period, which is the same language as in the insurance in the insurance. So unfortunately, the period you're suing for is like 2 or 3 years later, not 1 year later.
But in Essex, it was the second renewal period. This,
Counsel, you'll have time on rebuttal. We're going through this a second time. You may proceed.
Good afternoon. May it please the court, Sarah Zilkowski for the defendant respondent appellant, Thompson Flanagan. The record before the court shows that Thompson Flanagan filed a pre-answer motion to dismiss all causes of action asserted against this litigation on the grounds that the allegations in the complaint did not support a finding that it was the broker of record that secured the policies at issue. After the motion was fully submitted, the plaintiff filed an amended complaint and did not include any new substantive allegations against Thompson Flanagan and did not cure the grounds upon which Thompson Flanagan moved to dismiss the causes of action against it. The motion to dismiss was based on 3211A7, which requires the court to accept as true the facts pled by the plaintiff in the complaint. The original complaint and the amended complaint filed after the motion was fully submitted both allege that Thompson Flanagan secured the initial 2017 policy and the 2018 policy. The allegations of the complaint establish that plaintiff then placed their business with co-defendant World Insurance for the placement of the 2019 and the 2020 policies.
There was never a time that you had an obligation as their broker to tell them about this new provision? I mean, it looks like nobody seems to have an obligation to read anything. Which
And your client was the one person who was notified of the change.
Correct, Your Honors.
So why should he be dropped from his having dropped the ball?
There should be a break in the causal chain because the allegations of the complaint are that the plaintiff provided the successor, World Insurance Agency, with all of their policies, including the 2019 binder, and that the successor entity, World Insurance, then reviewed all the policies and recommended that they place coverage, would continue to place coverage with access.
Had your client done what he should have done as an insurance broker, then we wouldn't be sitting here in these circumstances, correct?
Well, the same argument could be made with respect to
Right,
World
but
Insurance, which
I don't see how their potential liability takes away from your potential. I mean, you can both be liable under somewhat different grounds. Well, you were the broker at the time that this big change from Axis came about. This is a pretty big change in the terms of their insurance policy, it would seem to me.
with all due respect, we're dealing with a denial in the 2020 policy.
I understand that, but it was the change during your client's representation where this change happened. So it was already part of the mix, right?
Correct.
And your client was advised of the change, and your client did not advise his client of the change.
And again, my argument would be that there was a break in the causal chain because all of the policies were provided to the next broker, and the next broker reviewed all the policies, and it was the next broker that recommended placement of the 2019 policy with Access. There's no allegations whatsoever in the complaints before the court that established that my client had any duty to the plaintiff with respect to the 2019.
I'm sorry. You don't have a duty to read an exclusion that's not in prior policies where the premium is still the same. You don't have a duty to advise the insured about that change?
Your Honor, I'm not saying that we don't have a duty to do so. It might.
Oh, did you breach the duty by failing to do so?
But that was not with respect to the policy periods at issue. And then the successor entity came on and reviewed all the policies.
So maybe if there is liability, it's as my colleague pointed out, there's going to be joint several liability and depending on the relative percentages of culpability.
Your Honor, I don't agree with that. I do believe that there was a clear break in the causal chain when plaintiff supplied, and it's plaintiff's allegations that he supplied all of his policies to World Insurance, and World Insurance reviewed it.
No, we understand that. Okay. Well, I speak for myself. I don't understand how, even if everything you say is true, you are out of liability. I mean, I'm getting the idea that so far, nobody thinks it's their obligation to read an insurance policy. It's an interesting theory. Okay.
Thank you.
Thank you.
Good afternoon, Your Honors. Judy Shamatzi from Wilson Elser. Your Honor, my client is not here to argue that they don't need to read the policy.
Okay, good, thank you.
There is a contract cause of action that remains in the case, and we did not appeal from it. And that's pretty much all I have to say. I think everything else is either duplicative or sort of...
Why is the negligence duplicative? There's a breach of contract, and the negligence, as I understand it, is that there's an obligation to read the policies and you fail to advise. It's those kinds of things.
And those are the same facts that would support, if they're borne out during the case, that would support the contract cause of action. And the damages also would be the same, which is what makes them duplicative. On reply, the argument was made that they're allowed to plead alternative causes of action, and that's certainly true, but those would have to be where it's one or the other. Duplicative causes of action, by definition, are ones where the elements are based on the same facts and give rise to the same set of damages. So that is why I believe that those are duplicative. The DJ, I think, is improper because you're asking for, again, sort of the same thing that you're going to get in your regular cause of action, and there's just simply nothing here that would support any kind of a fiduciary breach because this is a brand new broker. So they had wonderful materials that said how awesome they are, and they are. But this is not a long course of dealing between them where you would have that kind of a relationship. So unless your honors have any further questions, I'm going to go before the light goes on.
Thank you.
Thank you, your honors.
You still had time, but thank you.
Your Honor, if you may please the court, Dirk Karhoff, on behalf of Defendant Respondent Access Insurance Company. I'd like to introduce my co-counsel, Jason Cronick from Wiley Ryan, Washington, D.C. His Pro Hoc Vice admission was granted, and I request that he appear here on behalf of Access to argue.
Your application is granted, and I will spare you my speech. Welcome.
Thank you, Your Honor, because we do read the policies. We do it all day long, let me tell you. I'm Jason Cronick. May it please the court, I represent Defendant Respondent Access Insurance Company. At bottom, the appellant here just doesn't like the remedy that was provided by the trial court under Section 3426. Judge Schechter.
Can you address the Essex insurance argument? Because I'm having some issues with it. Counsel seems to suggest that they would be entitled under that case to the exclusion not applying.
Well, the second department's decision in Essex is a bit difficult to understand. I mean, at bottom, I think it's understood as a reformation case, because that's what the trial court did. But on appeal, the court, at the end of the case, has a brief discussion about Section 3426 and says it's implicated, but it's not exactly clear, because as Your Honor pointed out, at 688, the court, when it sets up the discussion, suggests that the remedy is that the policy is extended or the terms are extended for another policy year. But then it talks about that breach 2 years later, if you will, saying that the additional insured, because the claim was actually for the additional insured 2 years later. But there's a second breach in that case. To step back, we're talking about an exclusion here. In Essex, they're talking about repeated requests to add additional insureds because it's a contract where they're adding subcontractors. So actually, I think you can reconcile Essex, as we suggested in our brief, by saying that there are two discrete violations each time there's an ask and a refusal to add the additional insured. So you, in a sense, bootstrap. The policy's extended 1 year, then they say, how about another additional insured? And the insurer, again, doesn't respond, and so the remedy is to add another year there. I think that reconciles Essex, and as I say, Essex does seem to reference the notion that it is only extended for a year. It just then kind of doesn't get back to that.
Stepping aside from Essex, what about the insurance law? Isn't the insurance law clear on that?
I don't think the insurance law is clear at all. If you look at 3425, I guess it depends on what you mean is clear. 3426 definitely does say it's extended for another year in a different provision of 3426. And it seems to be the only practical, workable response here, because otherwise, as the trial court pointed out, it can't be perpetual coverage. Even Mr. Saratella doesn't believe it's perpetual coverage. And at the trial court, he mentioned that, well, perhaps it would be a reasonable inquiry. Well, a reasonable inquiry, what does that do to this bench's caseload or to the trial court's caseloads? If each case had to be examined and what the trial court's phrase was, the subjective equitable variables would have to be there. That's very difficult to apply. And as House shows, when you take that analysis, it tends to show that what makes the most reasonable approach here is exactly what the trial court did. You get a Band-Aid, you get the policy extended for a year, and then after that, the terms are what the terms are, which, based principles, that's what contract law is all about. And if I could just for a second speak about the Reformation, I think there's a recognition in the plaintiff's brief here that this doesn't really work and they need to shift gears and ask this court to give them a cause of action for reformation. And first, that in itself is significant because it shows that 3426 does not give you reformation and it doesn't let you renew the policy as 3425 would. Instead, all it does is say that these terms remain in effect for a period of time. So it's not reformation, it's not changing the policy. But more practically, stated simply and with all due respect, I just don't think it makes much more sense to talk about reformation here. In the first instance, as we pointed out, it's a breach in 2020, it's an alleged breach in 2020. So you're going to reform a policy in 2018 and somehow carry that over for 2 years because in that interim, I assure you, Axis was reading the policy. Axis issued that policy 2 more times and said hedge fund exclusion. And then, if I may, at the end—
You're on borrowed time, my friend. I'll give you 30 seconds.
30 seconds is fine. I just point out that the whole premise is they didn't see the exclusion. And now they're going to say, well, there's a mistake. We thought it meant something else. That's irreconcilable. That's all I have. I think Judge Schechter came up with a practical and a workable function here, and I think the case below should be affirmed. Thank you.
All right, you have time for rebuttal. 2 minutes.
Thank you again. Just to make one point clear about reading the policy, it's only the initial policy that the policyholder is expected to read. And that's what the Godkin case says. The Godkin case says that the protections afforded by the statute would be, quote, severely undermined if not eviscerated if the policyholder had to read every renewal policy. That case had to do with the sister statute of 3425, which is substantially similar. That deals with personal insurance. And I want to make something clear.
So you mean an insurance company is not supposed to ever be able to make any changes in its policy once it gives you a policy?
They can. They just have to notify the policyholder if there's a reduction in coverage. That's what 3426 says.
But fair enough. The issue still is what's the remedy?
So
and that's what I want you to address.
So I'll address one thing. Reformation is a remedy. Godkin talked about reformation. You can reform the policy and make it so that the exclusion was never added. And as a matter of fact, just to go back, because I looked at the Essex case again, the initial policy was in 03 and 04. The reduction in coverage happened in the first renewal in 04 and 05. The claim came in 05 and 06.
Your adversary argues that Essex is distinguishable because it concerns additional insured coverage, and this is an exclusion, et cetera, et cetera.
That's not what the opinion says. That's not what the facts say, and it doesn't even matter because whether it's a reduction in coverage or exclusion, it's the same thing. That's what the statute says, reduction in coverage or exclusion. So it doesn't matter if you're actually stripping something out in terms of additional insureds or adding something in terms of additional language that is exclusionary. So Essex is squarely on point. In the Godkin case, the claim came in years.
You got 30 seconds.
The claim came in years. I believe the change was in 05. The policy holder brought its claim in 09. And the court said that the exclusion or the reduction in coverage was not in effect. Reformation is a remedy, Your Honors.
Thank you. People versus Juan Rivera. You may proceed.
Thank you, Your Honor. Good afternoon, Your Honors, and may it please the Court, Rebecca Martin for Appellant Juan Rivera. Your Honors, Mr. Rivera has been battling heroin addiction since he was 16 years old, and the crime in this case was clearly linked to a relapse that happened after 7 years of sobriety. And given that context, as well as the other mitigating factors identified in my brief, such as his age and his illness, there was really no purpose served in giving him anything above the minimum sentence here.
Counsel, here he had 2 robberies with a weapon, 1 gun, 1 knife, hit one of his victims with the weapon, and the robberies are 5 months apart. So it's not like he had a relapse and had 2 back-to-back interactions. These were spread apart.
Yes, Your Honor. Mr. Rivera acknowledges all of that. We do not at all want to downplay the severity of his behavior, only to put it in the context of this is a person who had achieved sobriety for a long period, ended up relapsing in a very dark moment. He was widowed, he'd been living alone, he was ill, and that led to, yes, a very unfortunate time of relapse in which he did robberies in order to get money to support the habit that he'd fallen back into. But this is someone who wants to and has achieved sobriety, has been able to maintain sobriety, and he's been given conditional release from his current sentence, showing that good behavior in prison, and he's been doing the programming. And
Can you address the waiver, please?
Yes, Your Honor. So the waiver isn't valid. The oral colloquy very clearly stated that you're just waiving the right to appeal, period. No explanation of the rights that are that you can still raise or that you would still have an attorney. And the written waiver doesn't cure that for 2 reasons. First, because it was signed before the oral colloquy. The written waiver itself states that it should be coming after the judge has given his explanation and that you are able to ask questions of the judge. And in this circumstance, you can see...
But didn't the defendant have ample opportunity to discuss the waiver with his attorney?
He did have the opportunity to discuss the waiver with his attorney, but it is the judge's responsibility, not the attorney, to make sure that his understanding is clear on the record. And in this case, he signed that waiver at the same time as he was signing several other pieces of documents well before he got an explanation from the judge. And then the judge said something different than what was in the waiver. And he's in a courtroom. The judge is the ultimate authority.
The judge doesn't have to read the waiver verbatim, and there's ample case law that has repeated that time and time again. There's no set litany, right?
Absolutely, Your Honor. However, the judge also, you can't imply that the waiver is an absolute bar to appeal. And here the judge says, sir, at the bottom of page 12, sir, are you willing to give up your right to appeal in this case in return for the plea and sentence, period, after having explained what the right to appeal is. No hint that you would actually still be able to raise an appeal on some issues. And in that circumstance, Mr. Rivera had no way of knowing that it was the written waiver that was correct rather than what the judge, the person that is the ultimate authority in this courtroom, was telling him.
Now, counsel, your client, this is not the first time that Mr. Rivera has been involved in such a situation, is it? He's got priors.
Yes, Your Honor, he does have priors. However, his most recent felony had actually been almost over a decade before, and then his only other felonies had been in the 80s and 90s. And until recently, it wasn't really common practice for most misdemeanors to get appealed. So that doesn't necessarily indicate that he'd had any recent experience with an appeal waiver, such to remember the nuances that were lost here.
Okay, you'll have time on rebuttal.
Excellent, thank you.
You may proceed.
May it please the court, Charles Wan for the respondent. Your Honor, here, the defendant executed a valid waiver right to appeal.
It's not, what the court said wasn't great, right? Didn't really explain the differences, what rights were being given up.
The judge did not read from the written waiver, but he did ask the defendant, have you looked at the written waiver, have you signed it, and have you discussed it with your attorney?
She.
Sorry, Your Honor. The court did ask the defendant,
if the defendant reviewed the written waiver with his counsel, and if he had any questions. Defendant affirmed that he totally understood the waiver, which explained what rights he would still possess, that he could still raise on appeal, and that he understood it. And his counsel also affirmed for the court that counsel had discussed the written waiver with the defendant, and that defendant understood, there were no questions. So under the circumstances, the court did not have any reason to read from the waiver or ask any further questions to make sure if defendant understood the waiver.
Can you tell me how much time the defendant was looking at on each of these independent robberies committed 5 months apart?
I believe he, if convicted of the top charge of first-degree robbery as a second violent felony offender, he could have received this indeterminate sentence ranging from, determinate sentence ranging from 10 to 25 years.
And the second robbery could have been sentenced consecutively, correct?
Right, Your Honor. And so here he received a very lenient sentence in that he received a 6-year sentence with 5 years post-release supervision in light of what the sentence he could receive. If there are no further questions, we request affirmance.
Thank you. Okay, you have 1 minute.
Your Honors, I just want to touch on one other problem with the waiver, which is with the signed waiver, as I laid out in my brief, so I'm not going to get into detail, but I just want to emphasize that the signed waiver the written waiver, that also compounded the implication that no matter what, Mr. Rivera wouldn't retain a right to an attorney. So that in and of itself is a problem.
You're saying the written waiver did not explain that?
It didn't explain it. It said, it listed, normally you'd have all of these rights, including a right to attorney. You're waiving those rights, you retain certain rights, but the rights retained, it does not mention that you would have an attorney to raise those.
Was this the old form that the Bronx District Attorney's Office used that was later amended?
I don't believe so, but I'm not actually positive. I'm sorry, Your Honor.
Okay.
And I also just wanted to briefly touch on the protective order issue, just to emphasize that we really do believe that you should vacate that protective order in the interest of justice. As the prosecution conceded, it was not statutorily authorized, and there's really no interest in the state.
Wasn't the order of protection part of the negotiated plea?
It was, Your Honor, but there is...
And further, you didn't object to it, so this is not preserved, right? Had you objected, the lower court could have done something, or the people could have modified their offer or taken it off the table.
Your Honor, that is correct. We could have objected. However, your sister courts in the Second and Fourth Department have often reached this kind of claim in the interest of justice. Ultimately, this order was unlawful. It wasn't something the trial court had the power to impose under law. And for that reason, we believe it should be vacated in the interest of justice.
Thank you so much.
Thank you.
Mena versus 5 Beekman Property. You may proceed.
Thank you, Your Honors. May it please the Court, Tim Norton on behalf of the plaintiff appellant, Herberto Mena. The lower court erred in failing to grant our motion for summary judgment by finding an issue of fact with respect to whether plaintiff was the sole proximate cause of the accident. I think it's undisputed here that we established a prima facie case. It's undisputed that plaintiff fell through a 48-inch gap between the scaffold and the facade of the building itself.
Is this the case where you put in an expert affidavit, didn't you?
That's correct.
And amongst other things, they said even if there had been any safety harnesses, there was no place to tie off anyway.
Precisely, Your Honor. Even if you credit the testimony here that safety harnesses were available, there was no anchor point consistent with what would be good and safe practice according to OSHA and according to custom and safe practice.
So it's not good to tie safety lines to the scaffold? Is that what you're saying?
Correct. So the OSHA provision...
You would simply fall and bang your head up against the scaffold.
I'm sorry, Your Honor.
If you're tied off to the scaffold and you fall while suspended on a rope, your likelihood of banging into the scaffold itself on the way down is heightened.
That's precisely correct. And the testimony here, even from plaintiff's foreman, stated that even if he was wearing a safety harness, he still would have fallen through the gap. So a proximate cause of the accident is still that gap between the scaffold and the facade of the building itself. That's been stated by this court many times. In the Anderson and Migulata case, which we cited in our brief, they particularly touch on those points that with respect to, I see my time is almost up, but with respect to this speculative notion that—
That's the 2-minute light.
Oh, that's
Continue,
2-minute light,
okay?
Sorry. So with respect to this idea of like speculative tie-off points, that's not enough. There needs to be an evidentiary showing that there was actual anchor points which are consistent with being above the person working and have a 5,000-pound requirement to meet. And there's been no showing of that here. It's just been speculation, as was similar into the Miglianico and the Anderson case. And the Anderson case specifically dealt with an argument whether or not an OSHA practice was sufficient for a tie-off point. And in that case, the defendants argued that he could have tied off to a portion below him, which was inconsistent with OSHA, and the court rejected that and said that that's not a sufficient tie-off point. You can't just say that any tie-off point that exists creates an issue of fact. And furthermore, they also rejected the fact that there was an expert affidavit saying that a rake beam overhead could have been used. There was no evidence that there was a specific instruction that was given to the plaintiff in that case. So they said even if that was a particularly appropriate tie-off point, no instruction was given. There's no evidence in this case that a specific instruction was given that he could tie off to the specific scaffold itself, even if we wanted to get there and say that that could potentially be a tie-off point. And finally, I'll just add one more point. Even if this court found that the tie-off point to the scaffold itself was acceptable, a proximate cause of the accident would still be the fact that there was a gap between the scaffold and the facade of the building. So I believe that the lower court should be overturned and we're entitled to summary judgment. And unless there's any further questions, I'll rest at that point.
You'll have time on rebuttal.
Thank you, Your Honor.
Good afternoon. May it please the court. My name is Cheryl Fuchs for Appellant Everest Scaffolding. Plaintiff did not bring any claims against Everest. The third-party plaintiffs who sued Everest for breach of contract and contractual indemnification did not submit a brief in opposition to our appeal. So right now on appeal, there is nothing opposing Everest's request to dismiss the contractual indemnification and breach of contract claims. The lower court found an issue of fact as to which contract applied to this project, a 6-page document that was initialed and signed by Jimmy Downs, the president of Everest, who testified that this was the complete contract, or a 107-page document that had the first 6 pages plus an additional 101 pages that Everest Jimmy Downs testified was not part of the contract. Now, the third-party plaintiff brought in a witness to testify for his deposition who first saw this contract a week before his deposition. He did not sign it, he did not initial it, he did not authenticate it. He couldn't say one way or another if that was the contract. So Everest established its prima facie case that the only authenticated contract that governs this project was a 6-page document that did not contain any insurance or indemnification provisions. And I don't know if Justice Kapnick, if you're looking for it, but it's on page 700 of the record, the first 6 pages.
Someone gets hired to erect a scaffold for the building, erecting of a building, and there's no requirement in any of the contracts that there be insurance?
Well,
that would be the first case I ever would have seen on this kind of matter without insurance requirements.
Well,
I've never seen any labor law case without insurance requirements.
Actually, Your Honor, Everest is different than another contractor like the employer who's doing the facade work. We're a leasing company. I actually helped draft Everest's proposal that has terms and conditions where the customer indemnified them. There are many cases with Everest where they do not have indemnification insurance provision. But the thing is here is they sent Everest 6 pages that did not have any indemnity insurance provision. After the contract started, after they already installed the scaffolding, Everest followed up with them and said, hey, you never signed our contract. They send back a 107-page document that very same day. Before this accident ever happened, Everest sends an email saying, we didn't agree to any of this. This is not our contract. We agreed to the first 6 pages. Silence, nothing else. So the way of the law of contract is worth, they sent 6 pages. We said, hey, you never sent it back signed. They sent it back after our work was already installed, saying, here it is. And we said, no way, Jose, we didn't agree to that. Silence.
So why wouldn't that just raise an issue of fact?
There's one authenticated contract. They have no one to support that this 107-page document is actually agreed and accepted to. The only witness to testify was Jimmy Downs from Everest, who said, I signed the 6 pages. I sent an email saying I don't agree to it, and I never heard anything back from them. They never came back and said, oh, yes, you do. Too bad, oh, so sad. Their witness said they had never seen this 107-page document. They can't rely on an unauthenticated contract that nobody signed, nobody initialed. There's no way that they could rely on that. So right now, before the court is one authenticated contract that does not require Everest to defend and indemnify anyone. It's really too bad that these sophisticated businessmen didn't follow up with it. As Judge Manzanet pointed out, this is the first case. Well, that's too bad. They're business people. They need to do that. Okay. If they didn't do that, that's not our problem. With respect to the contribution and common law claims, the party that brought us in didn't submit a brief. I see that my time is up. I guess I can.
I'll give you another 30 seconds. Go
Thank
ahead.
you. OSHA says that you need to have a railing or fall protection. Railing would not have been practical here because it's facade restoration work. They're taking off the bricks. You can't put a railing.
I thought they were power washing the bricks.
And part of it was that day they were power washing, but part of the work
So that day they could have had a railing because water can go through a railing.
But OSHA says you could do railing or fall protection. The employer is required to provide fall protection. Plaintiff's problem is that there's no anchorage point. Great, the employer should provide the D-links. There are plenty of construction projects out there where they have D-links on the roof of the building where they're supposed to tie off to. That's not my job. I lease a piece of equipment, a scaffolding. I don't lease harnesses, I don't lease lanyards, and I don't lease D-links.
Got it.
Got a lot of words.
Spirited, that's good. You may proceed.
Thank you, Your Honor, and good afternoon. I'll be as brief as I can. Let me start off maybe with the last point that was made on this OSHA rule.
You're here for Broadway.
Yes, sorry,
Okay.
Guy DeRosier on behalf of, on behalf of, Smith Restoration.
Smith, okay.
Yes. So briefly, the last point that was made is that this OSHA rule, which is what they call this 14-inch rule, is the one that applies in this case. And even plaintiff's expert actually cited this rule in his affidavit. And that rule says simply that if you have a scaffold that is more than 14 inches from the face of the work that's being performed, you can use either a fall arrest system or have a guardrail. So that's kind of the premise of saying, well, there was no need to install a guardrail here. And that's also the cornerstone of plaintiff's 241-6 argument is this industrial code provision that says
You have a bigger problem. It's 240 sub 1.
240
That's your bigger problem.
Let me address that directly then. So what I would say on 240 sub 1, and let me address the point with respect to the tie-off point, because that is an issue that really didn't come up in this litigation at all until we got to summary judgment. This OSHA provision that's referred to by the plaintiff's expert wasn't even in the bill of particulars. The provision says basically anchorages used for attachment of personal fall arrest equipment shall be independent of any anchorage being used to support or suspend platforms and capable of supporting at least 5,000 pounds per employee, or shall be designed, installed, and used as part of a complete personal fall arrest system which maintains a safety factor of at least 2. Now, the plaintiff's expert, without having seen the scaffold, came out and said essentially that you can never tie off a harness to the scaffold structure because this would violate this provision. And what we pointed out in our respondent's brief is that, in fact, this is not even OSHA's interpretation of this regulation. What OSHA says, essentially, is that if you have a pipe scaffold like the one we have here, which is not a suspended scaffold, it's one that's built from the ground up, you can use the scaffold for fall protection to tie the harness. And this is something that both the Everest witness—
What evidence is there that there were sufficient harnesses on site on this day for the 10 men who were working? What I have in the record is that there were only 2 harnesses on site. They're about 8 short.
That's what the plaintiff testified to, but we
And
have—
who contested that?
We have testimony from the plaintiff's foreman, Mr. Rosa, who testified very clearly, and I can give you the site to the record site. It's on pages 1652 to 1654 of the record, that there was plenty of harnesses. Every employee had a harness, and everyone was supposed to wear their harness. And to the plaintiff's further point, that even if there were enough harnesses, no one told him to wear it. That's actually refuted by Mr. Rosa's testimony, and this is on page 1657 of the record, that on the morning of the accident, he actually saw the plaintiff wearing his harness, and he added that he would not have been allowed to leave the shanty and go to his work site if he wasn't actually wearing his harness. That, to me, raises an issue of fact. Now, there's one more point, if I may, just very briefly touch on, because I think it's important. One of the issues we raised here in our opposition is that we don't really know what happened here. And one of the points I think that's important is if we do believe this OSHA rule applies here, which is this 14-inch rule, that if there's not more than 14 inches between the face of the scaffold and the face of the work, then you don't need to have a railing. You can use a harness. We don't really know here that there was anything more than a 14-inch gap. The only evidence, the only witness who was able to estimate the size of that gap is the plaintiff. And if you look at the 2 photographs that the plaintiff himself marked, and these are Defendant's Exhibit A on page 1540 of the record and Defendant's Exhibit W on page 1562 of the record, what's interesting about those photos is if you look to the left of the photos, you can clearly see the planking of the scaffold. Now, why is that important? Because Mr. Downs, the witness for Everest, testified that each scaffold plank is 9 inches in width. Now, if the plaintiff is correct that there was a 48-inch gap, that means that, and I invite you to look at these photographs, between the edge of the scaffold and the face of the building, you would have been able to fit 5 of those planks side by side, and you'd still have 3 inches left of space. And I just don't see that in looking at those pictures. So there are issues of fact even as to what the size of that gap was.
Thank you.
Thank you, Your Honors.
You may proceed.
I'm sorry. With respect to the last point, plaintiff's testimony is unrebutted that he fell through the gap between the scaffold and the facade of the building, but you don't even have to take plaintiff's word for it. Roman Rosa, plaintiff's foreman, was specifically asked if he could have tied off to the portion of the scaffold, would he have fallen through to the 10 to 15 feet below? And he said yes, he still would have fallen. So this idea that the safety harness could have prevented the accident or could be raised as an issue of fact is simply a red herring. And with respect to the OSHA statement that tying off to a harness on a pipe scaffold is permissible, that comes from a advisory letter issued by OSHA with respect to the tie-off point having to continue to be able to support 5,000 pounds, and there's been no showing of that whatsoever. And not only is that inconsistent with OSHA, it's also inconsistent with Smith's own internal procedures outlined in their safety plan. If you look at 2106 of the record,
it talks about fall protection, and it states specifically, when vertical lifelines are used, they should be fastened to a fixed, safe point of anchorage, shall be independent of the scaffold. I mean, their own internal procedures state that this is not a proper safety point. If there's nothing else, I'll rest on my brief.
Thank you.
Thank you.
And you have 2 minutes.
Just to correct one thing that counsel said, Roman, the foreman, didn't say he would have fallen. He said he could have fallen. He was asked, is it possible that if he had been tied off, could he have still fallen? But he doesn't know if he would have fallen if he tied off. The point that I'm trying to make is that if he was tied off to a D-link on the roof, maybe he wouldn't have fallen. If he was tied off to a proper anchorage point, he maybe wouldn't have fallen. But an anchorage point, a tie-off, a harness, not our thing. We're the lessor of equipment. We lease the equipment. The employer is required to provide the safety devices. And so there is no evidence that what we did was improper in any way. So all contribution and common law claims against Everest should be dismissed. Thank you.
And last but not least, Servitor versus City of New York. May proceed.
Your Honors, if it may please the court, I'm the plaintiff appellant. My name is Philip J. Servitor, and I think Judge Tisch erred here because the contract, the stipulation of settlement that the defendants or the respondents are basing their argument on is what the one which I provided, all right? And in that, in Justice Tisch's decision, he states, presumably, in open court, Mr. Savini, my attorney, accepted and signed that agreement. I've documented in my briefs that there's no documentation of an open court or a last chance conference. That's all in the opposition papers from the respondent's trial attorney, okay? Furthermore, when we look at that on, I think it's in the record, page 27, all right, the respondent and the respondent's trial attorney said, the respondent's attorney and my attorney signed that document together, irrefutably. They keep saying that, but they never account for the third signature on there, which appears to be somebody forged my signature, which I raised the issue with Justice Tisch, my attorney, Hagopian, the city's attorney, all right, on December 23rd when we had a hearing, and also I raised it on December 15th. I also raised the issue, who crossed out on page 1, R25 of the record, where it says, to be determined, inserted $75,000. Of course, that's the respondent's paperwork. That's their documentation, and what it says in there, it says agreed amount with the New York City Department of Human Resources Administration. That's what it specifically states. The respondent's trial attorney, Hagopian, told Justice Tisch that's a standard $75,000 for liens. Okay, the respondent in his brief also stated the same. That is not what that's for. If you look at the affidavit of liens, 4B, it states negotiated between the HRA and the attorney. That's the only figure that could be put in there, not $75,000. Okay, I also, in the transcripts, I mentioned to Judge Tisch, I found an email. In that email, between Hagopian and my attorney, they discussed settling in January of 18. Okay, from that point on, every NICEF document about compliance was forged or colluded because the one document number 40 from December 18th, the email from Hagopian to my attorney says, I couldn't make it for the adjournment. If you don't mind, I will put in there inspection of a vehicle and an IME report. Mr. Hagopian prepared that whole document himself and signed my attorney and his attorney according to that email, which I have with me right here today. Lastly, the way the respondents word their stipulation of settlement in their general release is detrimental to the public, in so that the way they word it, they protect themselves and they put at risk the solvency of Medicare, Medicaid, and the Affordable Care Act, the way written, because what they do is they deflect the payments from themselves and put it onto those three programs, just by few words in their stipulation, total compensation, and the way they word the general release, that what they do in that wording is they transfer those costs to those things, which affects the public interest of everybody that contributes to that and that relies on that, and that puts it to the detriment of those programs. Okay?
Okay.
You know,
All right.
any questions, Your Honor?
No, no?
All right.
Thank you. You have 3 minutes.
May it please the court, Kevin Osowski on behalf of the city. The issue here is whether Supreme Court abused its discretion in denying Mr. Servidor's motion to vacate. For the reasons that we've laid out in our brief and for the evidence in the record, we argue that the court did not abuse its discretion and ask this court to affirm. Unless the court has questions, we rest on our papers.
Any questions?
Thank you, Your Honors.
Thank you. Court stands adjourned.
Should come this way. Doc? Should you come this way?